Good morning. Great. Another good crowd. On behalf of myself, Judge Borello and Judge Rick, we welcome you to the second day of our Grand Rapids case call panel. I can assure you that we've been diligently working on these cases. We've had the benefit of not only your briefing, but also the work of our research divisions and our chambers. Trust me when I tell you we are familiar with the relevant facts and the pertinent law, and so we ask you to focus on your salient points. I'm just going to review a few of the ground rules for those people that are new to the court. If both sides are endorsed, you have 30 minutes for oral argument. If only one side is endorsed, you have 15 minutes. If you would like me to keep time for you because the clock is behind you, I'll be happy to do that. And if your case involves a minor child, please substitute their initials because these proceedings are recorded and they're being broadcast as well. So with that, we look forward to hearing your arguments, and I'll call item number 11, docket number 370260, People of the State of Michigan versus Omar Dante Wilson. Good morning, Mr. Peace. You may.
Good morning, Your Honors. Attorney Josh Pease at the State Appellate Defender Office on behalf of Omar Wilson. Because I know the court has read everything, I'm not going to spend too much time here. We briefed two issues. The first issue was whether there was a double jeopardy violation. There were, I guess, kind of three subparts to that issue. First one was whether the double jeopardy motion was timely. The trial court relied on People v. Powers and People v. McDonald to say, no, it was not timely because the motion wasn't filed for trial. But as we noted in our brief, Powers was abrogated by Cooper and by McPherson from this court. That was not referenced by the court. This was not automatically untimely simply because it wasn't filed before trial. So we believe the motion was timely and the trial court erred in that regard. The second subpart is what was the date of offense for that earlier felon in possession conviction? And without rehashing everything I briefed, I do want to expand a little bit on the issue of an accurate plea. MCR 6.302 says the court must find that a plea is accurate before it can accept the plea. This court in People v. Brownfield said that when assessing the accuracy of a plea, the court examines whether the fact finder could properly convict based on the facts elicited from the defendant at the plea proceeding. In other words, if the only evidence against the defendant is the statements they made at the plea, could they be found guilty beyond a reasonable doubt? When my client at that plea hearing expressly and unequivocally denied that he possessed the firearm on June 9th, 2016, he put the court in a position where it could not properly convict him of possessing on that date, and instead could only properly convict for the date he admitted possessing the firearm, which we know from the prelim in that case and trial in this case was April 8th. So in order for that plea to have been accurate, the date of offense could not have been June 9th, as the prosecutor argued, must have been April 8th.
Has that plea been set aside? I mean, it is what it is, counsel, right? I mean, how you're asking us to ignore the date that was accepted as by the trial court as the date for that plea.
Well, the trial court didn't really accept a specific date. The trial court asked, were you in possession on June 9th? And he said, no, I was not. The court found there was another date he was a felon in possession.
Well, the court said there was a photograph showing you holding that gun on, what was it, April the 8th?
April 8th, yes. He was a felon in possession April 8th. My client has never denied that. He was a felon who is prohibited from possessing a firearm. He possessed a firearm. He took a picture of himself with it. On April 8th, he was violating the law. But the
this matter happened on April 20th.
May 25th.
May 25th, what
The-
is April? Okay, I'll take your word.
Oh, yeah.
I Scrivener's error, Mr. Peace. Okay.
So yes, like the Michigan Supreme Court has said in regards to an information, some variance between the date of the charge and the date of the proofs is not fatal. So the fact that there was this variance in what the prosecutor charged him with and what he admitted to isn't fatal to the plea itself, but it is relevant to this issue of continuous possession. And we do, I think, have to focus on what was the actual date of offense and not simply what date did the prosecutor put in their information. And that's why we have to look at what was said at the plea hearing. What do the actual proofs show? And the proofs show that he possessed on April 8th. The proofs do not show that he possessed on June 9th. And that segues into that third subpart of continuous possession. Assuming that the date of possession for the first offense was April 8th, there was no evidence beyond the reasonable doubt on the record to show that he stopped possessing the firearm between April 8th and May 25th, which is the date of the second conviction. And it is the prosecutor's burden when we're talking about continuous possession to demonstrate that there was a break in possession. The prosecutor didn't do that. We know that there was testimony that about 9 p.m. or so on May 24th, a witness saw him with the firearm. But there was no testimony about what was going on between April 8th and that point on May 24th. And then after that point, there was no more testimony about what was going on with the firearm between when that witness saw it and when we switched over from May 24th to May 25th. So the record simply does not demonstrate that break in possession from April 8th to May 25th, which creates that continuous possession. And because it's continuous possession, he can only be rightfully convicted one time, and this second conviction becomes classic double jeopardy. The second issue we briefed was about the proportionality of the sentence in light of the snow factors. Unless the court has questions on that issue, I would simply rest on the briefing.
I mean, there's a presumption that it's proportionate.
There is a presumption it's proportionate. I understand that. That's why we argued that we believe that we have overcome the presumption. But again, I'm resting on my briefing on that issue.
I see no questions, so thank you very much for appearing, and this matter is submitted.
All right. Thank you, Your Honors.
We'll move on to item number 12, docket number 369362, People of the State of Michigan versus Lloyd Jarvie.
Good morning, Your Honors. May it please the court. The first three issues are really the one issue. It's all about his attorney conceding his guilt and what happened after that, whether it be by omissions by the court or his counsel.
Okay, so I have a question about this. So you're saying that the issue is preserved, and the prosecution is saying that the issue is not preserved because reading the opening statement, it seems that what he was dissatisfied with was a motive that he says counsel put forth. Not, I mean, the facts here are much different than in the United States Supreme Court case, right? Where the defendant wanted to maintain that there was some conspiracy to frame him as though he looked guilty. That's not what's going on here. He admitted that he hit her. He admitted that he took the car. He was found in possession of the car in another state.
Well,
mean-
Mr. Jarvie had also filed a motion to suppress his, and that's issue 4 here too, to suppress his confession.
Okay,
So at that point, it is his prerogative to determine whether or not he wants to admit guilt to this.
but he lost that motion in the trial court.
He still had the ability to preserve it and still to appeal that decision possibly. and having it on the record and having it put in front of the jury that he admitted to it, he was not in agreement with it. And it was,
Oh, okay, but so that's not how I read it. I read it as though he admitted that he hit her to stop her from yelling. But his attorney, based on his interview with the police, the defendant said that he was trying to knock her out and he stopped striking her when she went silent, basically, is how I read it. So I mean, I think the attorney said what was in the statement that he knew was going to be recorded. The attorney's position in this case was he didn't intend to kill her. He's charged with assault with intent to commit murder. He didn't intend to kill her, and there has to be a specific intent to kill. It's not, I'm innocent of this crime.
and also what the defense attorney said in his opening was not even consistent with the facts. There was nothing in Mr. Jarvie's confession that said he hit her in order to take her car and money, which is what the defense attorney said in the opening. Mr. Jarvie did say in his confession.
He took her car and money. I mean, he probably took her purse, but
There's a distinction there between him saying, or between his attorney, first of all, saying an opening statement, something that's not supported by the facts, that was his intent to take her car and money.
but opening statement, as the court later found, is not evidence, and the jury's instructed on that point, right?
And the results in this case of Mr. Jarvie not being heard by his defense attorney on the way that he wanted to present this case, and then not being heard by the court on the issue of, on this issue, led to larger consequences and more unusual
What do you
consequences.
mean not being heard by the court? That's a due process deprivation. When was your client denied due process?
When he filed this motion after the first day, as soon as that opening statement happened, he filed a motion on day 2.
The court took it up, did it not?
The court said, I've received it and I'm
Answer
setting
my
it aside.
question, yes or no? Court took up the motion, yes or no, counsel?
Yes.
Now, your complaint is, his complaint is they didn't do it fast enough.
Correct.
That's a different argument than my client wasn't heard.
The consequences between the filing of his motion for new counsel or to dismiss his counsel because of that opening statement and waiting until the end of the trial were that my client appeared, now albeit the court attempted to focus the camera, he refused to participate after that point. And he was shirtless and restrained from the jail for the remainder of those proceedings.
Whose fault was that?
I mean, it
Was
may.
that the court's fault? That your client refused to participate?
I
Or was
think
it your client's fault that he chose not to participate? As I suspect one who's been through the criminal justice system numerous times, this might have been a new trick for him, don't know. But he made a conscious decision. The other thing, counsel, is, and Judge Leddick is much nicer than I am. So I mean, let's be candid. You have a client who went in, beat the living you-know-what out of his ex-wife, so it's not like she can't identify him. He takes off in her car with her things, gets caught, confesses that he in fact beat the you-know-what out of her. He went too far. Now your trial, you bring a Walker motion, denied. You bring a motion to go down to simple assault, denied. Your trial counsel, what would your defense have been in this case?
I would have attempted to speak and communicate with my client and have a.
It's not a defense. What would have been your defense in this case, given those facts?
Really, as a defense attorney, and I practice at the trial level as well, I think coordinating with my client and meeting them where they are at to formulate a plan that's satisfactory to them so that they can participate and be satisfied with
You going to
that.
answer the question, or is this going to be your pat answer? I want to know, you're claiming that counsel was ineffective. I want to know what you think would have been an effective defense given the facts as they are presented in this case.
Well, respectfully, what the court's asking of me now is to prove prejudice, is to prove, okay, how would you have won this case? And in this case, we don't have to prove prejudice because this is a structural error on two grounds, not scrupulously honoring his right to remain silent by the police, and then not addressing timely his motion to withdraw his attorney and to,
That's not what he called his motion.
Not at all. Not even close.
He called his motion to dismiss or motion for, then in that motion to dismiss, he asked for a mistrial.
correct. And I think his attorney could have jumped in there at that time. And again, if you're going to ask me what I would do, that's what I do. When my attorney says, hey, you're fired, or when my client says, hey, you're fired, I file a motion to withdraw and explain to the court what's going on. His attorney stood silent. He stood silent when he could have helped him with it. And I think he should have. And I think his failure to help him with it and to address the court and just standing silent further exacerbated Mr. Jarvie's unwillingness to participate in this process. That
So it
since
was
the
his
beginning,
attorney's fault that he didn't participate,
I think,
partially.
yeah.
Okay.
All right, do you want to talk about the suppression motion?
It's, very simple. The only notes I have on this, in addition to what I filed, is that Miranda says it should be scrupulously honored. And when he says, do you want to talk? Do you give up your right to remain silent? And he said, no. And then the officers immediately asked him a question. Mr. Jarvie said, that's a question.
Okay, well, let's put it out there. So the officer said no, and then said, how come?
Right.
And then Mr. Jarvie's response back was, that's a question. And then the other officer jumped in and he said, he introduced them. And then he said, yes, we did come down here to talk, but you don't have any obligation to talk to us and you've invoked that right. And then he said, well, how about we do the pass or play game?
I don't understand why Miranda would say it should be scrupulously abided by, scrupulously honored without any caveat and not overturned if it doesn't mean scrupulously honored. When he says no, it should stop.
But you would concur that Miranda protects a defendant against custodial interrogation, correct?
Yes, Your Honor.
What was the interrogation that took place after your client invoked, other than the statement that you just told us? Is it your position or your client's position that when the police officers introduced themselves, that was interrogation?
I even think asking how come. Yeah, I mean, how come can lead.
I'm sorry, I didn't hear you. You think what?
Asking how come. The
how
officers
come?
before they introduced themselves, they said, how come? That's interrogation right there. How come? What kind of answer could that lead to? Because I did it? Because I'm guilty?
And your client correctly responded, that's a question.
So it didn't, so just because my client didn't fall into the trap of that, doesn't mean it wasn't an interrogation, doesn't mean it wasn't a question meant to elicit incriminating evidence.
You and I are not doing well here today. I agree with
That's
you.
fine.
That's interrogation. My question was, after the second officer gets involved, I think he's an MSP. After the second officer gets involved, he says, I'm so-and-so, this is so-and-so. And my question to you is, was that interrogation under Miranda?
In him introducing himself?
Correct.
I don't want to concede that it wasn't, because then my argument fails. But I think practically speaking, when you've been interrogated after you said, no, I don't want to talk. And then you have a second person, that's a show of force. You have a second person coming in and continuing with another line of questions. I mean,
He didn't continue with another line of questions. He said, this is who we are. We did come down here to talk to you, but you've now invoked your right to remain silent. So, and that's your right.
I think the addition of the second person continuing to talk after the first person continued to interrogate led my client to believe that his rights were not going to be scrupulously honored, that this was going to continue to go on. He's in cuffs, he's in a cell, and he suggests something that he think might give him some measure of protection that his invocation of his rights did not.
But the standard is not what your client would have believed, right? The standard is what would a reasonable person have believed. And so the question then becomes, would a reasonable person have believed at that time that their right to remain silent would not have been honored? And your contention is yes, because the police officers continued to speak after he had unambiguously invoked his right.
Yes, Your Honor, I'm
That's your
comfortable
position.
saying that a reasonable person, not just Mr. Jarvie, but any reasonable person would think, well, that didn't work. Invocation of my rights didn't work.
So I better talk to these people or I'm in trouble, or he felt coerced then? That's the basis of the coercion?
Yeah, I mean, we've already kind of established that it's inherently coercive to be in cuffs, detained, in any way. He was officially
And in
detained.
Wisconsin, I mean, let's not forget that. I mean, of all the places the guy could have gone, it's like my family emigrated from Sicily. I'm like, Saginaw? Saginaw? Right? This guy goes to Sheboygan. I'm like, gee, buddy, I don't know. Was there a big boy there? I mean, what takes a person to Sheboygan? We'll have to ask him about that.
His longtime buddy.
That was right. He had a friend there. I forgot about that. Well, I take your point. What I'm trying to get at because I think there's an argument here on this ineffective, but you have to admit, and I'm not a law school professor, so I'm not trying to trick you. I'm actually trying to weed through this. Whoever was this client's counsel didn't have a lot to work with, right? I mean, we can all agree as to that. Now, one strategy, of course, would have been to sit back and wait and plow holes through the prosecutor's case, but it seems to me that's not really a strategy. So going after, I guess what I don't understand in your argument from your submissions and today is it your position that defense counsel shouldn't have focused on your client's intent? Is that the overarching theory here that leads us to a finding of ineffective?
Again, and I don't have this right at the tip of my tongue. I hope it's in my brief, but the deprivation of your right to assert your innocence and continue that in front of a jury, that's a structural error that doesn't require showing of prejudice. So that's where we stand there.
Got it.
Again, my problem is it that, or was he focused on his, the error that counsel made in opening? Because I just don't see here that the defense was, hey, there was this big giant conspiracy to frame me for taking the car, and somebody else brought the car that had my wife's blood in the ex-wife's blood in it, and I had nothing to do. You know what I'm saying? It's not that situation.
I believe that in this situation, that I think that the defense counsel should have worked collaboratively with Mr. Jarvie, and he should have been in agreement with it. And this is why I didn't request a Ginther hearing on this matter, because the record is clear that Mr. Jarvie did not agree with it. He was, taken aback and immediately filed a motion that night. This is not what I wanted.
I guess my problem is I'm having I'm having difficulty seeing the difference between I hit her to stop her from yelling, and I was trying to knock her out so she would stop resisting. To me, that doesn't say, I'm saying regardless of this mountain of evidence against me, I didn't do this. I think that's what the United States Supreme Court case is aimed at, and not this statement during opening, which I think was the focus of his motion.
What I'm hearing is you're not so much troubled that defense counsel can't argue, listen, my client did something. what they did is for you to decide. Your contention is it should be the client's decision as to whether that argument is made. Is that?
And I think that position is supported by case law.
It's an interesting case. I mean, I don't think your client helped himself by not talking. Fortunately, we don't really know because he wouldn't tell us, so that didn't help him. You did an excellent job for
Right.
him.
You have time for rebuttal.
Thank
So
you.
let's hear from Mr. Morton.
Good morning. May it please the court. Assistant Attorney General Brent Morton on behalf of Dickinson County.
How come your pen is bigger than ours? We got these dinky little pens, right? That say Court of Appeals. You got like member of Congress pen there. That's just wrong. I think we should have bigger pens.
the more important you are, the less you have to flaunt it.
Oh, I
So,
guess,
There
yeah.
you go.
Of course, everybody, waits with bated breath to find out who's going to be next on the Court of Appeals because, we're so widely watched.
Yeah. And who's going to be next in, is my boss. So,
That is
Same sort of
correct,
thing.
yeah.
well, a defendant does have a right to autonomy, has a right to control his defense, but he's got to communicate that right. The case law is pretty clear that if the defendant doesn't say, I don't want that defense used, the attorney can make the decisions, make the tactical decisions. And here, as you've discussed, Judge Morello, he had an interview where all he could fight was intent. And that's what he did. And at no time did Mr. Jarvie get up and say, I don't want that defense used. He threw a fit the first time because he was misquoted in openings. His motion was a claim of ineffective assistance of counsel. And then when the attorney tried to argue on his behalf, when the trial court asked him to waive the attorney-client privilege, which goes to the heart of a claim of ineffectiveness, he wouldn't answer. So I appreciate opposing counsel's opinion that, boy, defensive counsel should have been more collaborative. Well, defendant should have talked to his attorney and said, I don't want that used. If he'd stood up after opening and said, Your Honor, I don't want that as my defense, then the trial wouldn't have continued. We would have, things would have changed, but he wouldn't talk. He wouldn't participate. And so we can't just blame the defense attorney for doing the best that he can with what he had. And what he argued was there wasn't the intent.
I honestly don't know what else you could argue in this case, given the facts. Like I said, you've done a Walker hearing, you've asked for the lessers. You've got a guy who's committed a crime against an ex-spouse. ID's not going to really be an issue. And if it was, you got the confession, you've got him with the car keys, you've got him with the car, you've got him admitting it, you've got the injuries, you've got the expert testimony as to the extent of the injuries. As I said to sister counsel, I suspect you could sit there as a defense attorney and wait for the prosecution to make a mistake and then seize upon it. But outside of intent, I don't know what's at issue. What was at issue in this case?
Well, and particularly since during his interview, he talks about, I was going over there to ask her for a car and $800, I think
Wanted
specifically.
800 and he owed her what, $4,000 as a result of a divorce case?
I believe it was
So I
$100 a
just gonna
month.
put
but-
the 800 on the tab, I
Yeah.
guess.
Well, let it ride. No, I'm sorry. I don't mean to make light of this.
No, I don't either, but I mean, this is what we have. What do you think about the sister counsel's argument regarding the Miranda violation?
Well, we don't believe it was an investigatory question. It wasn't, the question of how come was not meant to prompt an incriminating response. The introductions, the explanation, look, they go in to interview somebody who's like, I don't want to talk to you. Okay, well, we probably should have done this first. Let's introduce ourselves. You don't have to talk to us, but we want to talk to you about this. So I think they're just giving him information so he can make a decision.
But you're not in denial of sister counsel's argument that that the defendant had invoked his right to remain silent, and that after that, in that invocation was unambiguous, and then after his invocation of his right, the police officers asked him a question. How come? Why won't you talk? Right?
Well, but
Was that a violation?
no, because it protects against investigatory questioning and custodial interrogation. It wasn't interrogation.
Well, how does
now-
that fit into scrupulously honor an unambiguous invocation?
I might want to concede this one.
Well, I will throw this out there. Look, it protects two rights, the right to an attorney and the right to remain silent. And so without finding out more of why won't you talk to us, I don't know which right you're invoking. Look, this is an
Does it
attempt to.
matter?
Wow, that's a new line.
Well, I think it could matter depending on the seriousness of the case. This is an extremely serious case, and they may have been willing to try to get counsel to
Mr.
assist
Morgan,
them. But-
I think.
but I'll stop
Scrupulously honor means scrupulously honor.
Okay.
I don't know how much clearer the United States Supreme Court could have been on that point.
There was a violation here. The question is, was he then subjected to continued custodial interrogation in violation of Miranda, as I see it, and I suspect how the PJ sees it as well.
And we, of course,
Disagree, I understand.
and also, and taking into your analysis of that, you should also consider the totality of circumstances and the Cipriano factors. This was not, it wasn't hours. He wasn't, the interview wasn't continued for hours and hours longer. And he finally said, oh, I got to talk to these guys. They had a short discussion and then they continued with him controlling the interview and not answering questions he didn't want to answer.
So no, but even if there was a Miranda violation, was it a cured violation by the second? What we haven't gotten into was there was and I can't remember the names of the officers, so forgive me, but the second officer gives him Miranda warnings again, if I'm not mistaken. And is this the case where he gave him? Yeah. So after they ask him how come, then the second officer steps in and introduces himself and the first officer and then says, you don't have to talk to us, and then reads a Miranda again. And that's when the defendant says, well, let's play pass or play, right? That's
And we believe it was cured
Okay.
by that, by him being able to
that
control
there
it.
was an error, which there wasn't, but I get that. All right.
But thank you. I'm happy to answer any other questions.
As always, it's a pleasure to have you in court, sir.
Great to see you all. Thank you.
Thank you very much.
All right,
Appreciate your
thank you.
time
Thank
and
you both.
submission.
Yes, this matter is submitted. We'll move on to item number 13, docket number 374435, Colby Taylor versus Kristen Taylor. Oh, no, is anybody hearing those? Okay.
Eric Phelps, counsel for
Okay.
appellant, cross appellee Kristen Taylor.
All right. We
And
have
may it
this.
please the court.
Yes, you may proceed.
Thank you. We've raised two issues on appeal. The first relates to the trial court's validation of the investment theory, which we assert is an abuse of discretion. The evidence from the plaintiff, Mr. Taylor, from multiple witnesses, and from the defendant, Kristen Taylor, was clear that up until the time he determined to file for divorce, that the arrangement with plaintiff's parents was that they were acting as the bank and that the money they provided for the purchase of the home was a loan. This shifted at the time that Mr. Taylor determined to file for divorce, at which point he first took the position that defendant had zero interest in the home because her name wasn't on the deed.
That's
No.
correct.
No contribution theory, no record title interest, nothing like that.
Right, she was having complications.
She was pregnant and she
Time,
was
yes.
spotting, and the plaintiff's testimony was that she was hemorrhaging blood. The defendant's testimony was that she was spotting. She didn't go to the closing. Mr. Taylor conducted the closing in the name of his father and without any knowledge or statements to Mrs. Taylor, put his parents' names on the deed and didn't put her names on the deed. the subsequent course of dealing is what's relevant here. I asked Mr. Taylor, I said, basically, when did you decide this was an investment? He said on April 18th, the conversation I did have with my parents at the time is that we can figure out what we're going to do with this at a later time. If it's going to be a loan, if it's going to be something I need to figure out later, or if you want to remain investors. So in the plaintiff's own words, he didn't know what he was doing when he put his parents' names on the deed. And at that point, frankly, was never clarified. What was clear was that he told everybody within his circle, including the defendant, that his parents were acting as the bank in that they were giving a loan that had to be repaid. He told Joy Vanderlee that that was the case. She testified that the parents Mr. Taylor stated they had difficulty getting a bank loan. His parents were called and they agreed to loan the money.
I think we understand the facts are, I think what PJ Letica is asking you is, what exactly is the basis of your legal claim here? Are you contending that the trial court abused its discretion by finding that the credibility of the parents was something that the court considered in making its decision, or is this an error of law? Where exactly is the appellate error?
Thank you, Your Honor. I think it is an abuse of discretion in the weighing the testimony of the parents of the plaintiff, who obviously have a bias toward the plaintiff, more heavily than 4 separate witnesses who came, actually 5 witnesses, Joy Vanderlee, Jessica Hugendorn, Steve Karras, Joseph Culbertson, and Kim Fleming, who all clearly testified that the plaintiff told them it was a loan, they were paying it back. The defendant's testimony about how the parties treated it in their course of dealing, there was a ledger, there were regular payments. When the land contract on the first home closed, they paid down a $20,000 payment. There were communications between defendant and plaintiff's mother as to how much money was owed. Kim Fleming testified that at one point the defendant told her, we only owe $40,000 on the loan from the parents. All of the contemporaneous statements from the parties in the witnesses was that this was a loan. The parents testified there was no lease. They didn't claim rental payments on their tax returns, but conveniently at the time the defendant states when he files for divorce in a text to plaintiff in a text to the defendant that I'm just learning about this now, instead of I've told you you have 50% in the house, but now I'm just learning you actually don't have anything in it. And it's an investment, not a loan. It's a contrived theory. And in response to your question, Your Honor, yes, I believe the court abused its discretion in weighing the testimony of the parents above the testimony of the other witnesses.
The trial court determined there was an absence of any documentary evidence of the loan, and you've listed off a number of testimonial things. Is there anything in writing that would support, other than the ledgering, which I think
The ledger is
probably
the
go
ledger.
either way.
The ledger, Your Honor, is the contemporaneous record of the loan. So
you're relying upon the ledgering
Well,
as the
the ledger-
existence of there being a loan.
the ledger and the testimony of the parties and the statements against interest of the plaintiff to multiple parties. It wasn't like he just said it once. He said it to, I think one of the witnesses said he wanted to talk about it a lot. He talked a lot about it, that the parents were acting as the bank, that the money advanced was a loan. And so, again, for over 10 years, Mr. Taylor took the position, parents were the bank, this was a loan, it's our house, we're repaying it. Then all of a sudden he gets an attorney. The attorney says she's not on the deed, she doesn't have any interest, and he sends a text. Geez, I was wrong. I'm just learning now that you don't have any interest in the house. I don't even have 50%. That's the argument, Your Honors. I think it's also relevant and important when you look at the testimony of rebuttal witness Kim Fleming, when Mr. Taylor told her shortly before the divorce that he had a plan and that he was planning that Kristen would not get any money from the home. Then he followed that up by saying he didn't think she was simply smart enough to figure it out.
Counsel, what we're talking about here obviously is a divorce action, and we're talking about third parties, correct?
Right.
So how does the trial court get jurisdiction in this case over the parents?
That's where we cite the Donahue case in our brief, Your Honor, where in the Donahue case, the husband's parents in that case had gifted bearer bonds to the parties in the amount of about $195,000. They put the bonds in the name of the husband and the parents only, and there was an attempt to not, or to argue that those weren't marital assets because the wife's names weren't on them. In that case, the court said the deception, the act of attempting to convert this marital asset, the gift, into a non-marital asset allowed the court to address the issue of third-party rights in the divorce context.
So in order for the trial court to assume or have jurisdiction over the parents in this matter and to set aside the deed, which is in essence what you were asking, was it necessary to prove that for your client to prove a conspiracy to defraud?
I don't know that conspiracy was the proof that there had to be, Your Honor. I think the intent.
So is that a yes? Yes, there has to be a conspiracy in order to get jurisdiction over the parents, or no?
I think under Donahue, that's a no, Your Honor.
Okay, so you didn't have to prove that there was a conspiracy to commit fraud. You just had to prove there was a fraud per Donahue. And Thames, I know you quoted Thames as well. Okay, thank you.
Yes. We also raised what Your Honor is alluding to, which is a fraud argument. That's our second argument in the appeal. And so if the investment theory is accurate, if the court determines that this really was an investment, the question is, was there fraud between the plaintiff and the defendant? Well, he knowingly misrepresented to Kristen that his parents were the bank, that the money was a loan, that they were paying it back. They paid back over the course of 10 years, $89,000 of marital funds. There was no discussion of a lease. There was no discussion of rent. It was always, it's a loan. My parents are acting as the bank. She relied on it. She made the payments. She used marital funds that could have otherwise been used for other things. And she was deceived by it. And so he ends up benefiting from the fraud, where at the end of the day, based on his parents' testimony, that he will get their interest in the home. It's a 75-25 split on the house. Happy to answer any questions that the panel might have. Thank you.
We have plenty of time for rebuttal. Ms. Parker?
Good morning, Your Honors. Elizabeth Parker, appearing on behalf of Colby Taylor, appellee and cross appellant. In response to the arguments that you've just heard, I think that it really boils down to the point that Judge Barella made, which is in order to succeed on, quite frankly, either argument, this court would need to find an abuse of discretion that the trial court, who we know sat in the best position to make credibility determinations, abused its discretion when it found that the testimony from the parents was convincing to her that they had in fact actually contributed these funds and they had in fact done so believing it to be an investment. I think it's significant that going to this idea of a loan, and obviously the trial court thought that it was significant as well, that there was no documentation of it. Yes, there's this ledger that was kept by Ms. Taylor. There's never any acknowledgement of that ledger that was not, co-signed by the parents of Mr. Taylor, nor an initial acknowledging its existence or the balance due. It's just a sort of a self-serving document that she kept track of. So I think, quite frankly, in order to really reach either of the on either issue, advanced by Ms. Taylor, the court would have to essentially set aside the trial court's credibility findings. And I don't think that's something that's lightly undertaken, and certainly not in a case like this where there's conflicting testimony. I mean, there just fundamentally there is, and it's in the nature of divorce that people remember things suddenly in a way that helps them and not necessarily helps the other side. And the court found that the parents were the most credible on that issue. And I think it's
Ms. Parker, if I could I interrupt here? I'm, like a jazz trumpeter or some, you don't take a breath. So I gotta
apologize
sneak
for that.
in, when I can. I'm gonna go out on a limb, first of all, and guess you have an affinity for cats. Would I be right
You
about that, or?
you would be right. You would be right.
Well, I have to ask now, what kind of cats?
Well, I have 7.
You can never have enough, right? I mean,
My priority cat is a Siamese. So
okay. Yeah, my parents bred and raised Scottish Folds and Devon Rexes for many years, along with Irish Wolfhounds. So I come from a long line of cat and dog people, which is why I don't have cats. But
you've
anyway,
learned your lesson.
I learned the wonderful. Actually, I don't have them because my wife is very allergic. But wonderful animals. Picking up, my colleague Judge Rick brought up the ledger, and I thought she asked a very good question, and I want to put it to you about this lack of documentation. And your point is well made, but it occurred to us while we were reading and discussing this case that there was that issue can cut against your client. And here's specifically what I'm thinking of from the record. As brother counsel elicited in his argument, there was this $20,000 payment from your client to his parents after the closing of the initial house. And your client's mother testified that that was, in her opinion, that was a repayment of a college loan. Do you recall that testimony by any chance?
I do.
Okay. Was there any documentation between your client and her son regarding repayment of student loans?
There's nothing in the record to indicate that there was documentation of that. I don't know that there was ever any inquiry. So it's possible, but it was not an issue that came up during trial.
So why is it then that we can hold or conclude that what, we don't know what this was because there wasn't any documents, but your clients testified thusly, but the same holds true relative to this so-called student loan. Do you follow what I'm asking? That wasn't the best way to ask it, but thank you. Go ahead. I'm sorry.
I do. And I think the reality is we go back to what the trial court concluded, not just on the issue of credibility, but also she found that it was not credible that there would be a loan for such a large amount, interest-free, and that there would not be a documented writing. I think it further, in an instance like that, you would have something more akin to a mortgage, and you wouldn't necessarily have parents who would also then appear on a deed. They would have a recorded mortgage interest, a recorded loan, and under those ordinary circumstances. Here, it's not just the testimony, but it's also the actual conduct of the parties and the documentation that we do have that supports the idea that this is in fact intended to be an investment by them. I think it's important to think about the fact that, when we sort of step out of the family law context and we think about it in a statute of frauds context, I mean, if it were a loan, it would not pass muster under the statute of frauds and could not be enforced. And that's the type of thinking I believe that the trial court was contemplating when she concluded that under the facts of this case, the documentation, that being the deed, as well as the conduct of the parties, was more consistent with the determination that it was an investment.
Thank you.
Thank you. And I think that's really where Donahue is very distinguishable from the facts of this case. I I mean, there were admissions about, we were actually trying to conceal this from her, and there were safe deposit boxes and, all types of nefarious conduct that was not out in the open. And even there, the Court of Appeals said, well, it's a close case, but we're going to defer to the trial court's decision as the best judge of the credibility of the witnesses. And I would argue that in this instance, that same reasoning holds true. The trial court here had the best opportunity to evaluate the witnesses before her and to make that determination. And I believe this court should affirm that. I am assuming you would like me to move on and present my arguments as cross appellant at this time.
Can I ask one quick question before we pivot to that? And that is the same question I posed to brother counsel about the courts obtaining jurisdiction over the parents in this matter. Is it your contention that there had to be a showing of a conspiracy to commit fraud? Or is brother counsel's contention that simply demonstrating fraud was sufficient for the court to have assumed jurisdiction over the parents?
I believe in order to set aside the deed, there would need to be a finding of a conspiracy between the parties.
Is there a particular case that you can think of? And I don't mean to put you on the spot, but if there is, fine. If not,
If I'm recalling Cassidy correctly, there were some findings there that were suggestive of interaction, conspiratorial type of behavior between the parents and the child.
Thank you again, counsel.
Thank you.
Could you briefly, counsel, if I may, could you briefly address the disproportionate distribution argument, which I think would not implicate necessarily undoing the deed or the parents, but rather the Sparks analysis of whether this was a disparate distribution of marital assets?
I'm not sure if I'm following. Are you referring specifically to the distribution of the house?
I think more broadly, as we tally up, obviously the house is the primary concern, but if we tally up the distribution of all assets, is there and we assume that there isn't the existence of a conspiracy, to Judge Borello's line of questioning, I guess my question is, under Sparks, would there be a method or manner that the court could have adjusted the distribution in a way that would be equitable without implicating those parents, assuming that we're left with a bad taste in our mouth that something's not right here?
I mean, I would argue, and again, that's kind of, I haven't really researched that specific issue about getting it outside of the fraud framework, since that's the way it was presented. But no, I mean, there's nothing about the ultimate distribution that is inequitable to Ms. Taylor. She is theoretically gaining more than what Mr. Taylor is from the house, because as between him and his parents, as far as they're concerned, they still have a 2/3 interest in that house. And so, if we're not, I don't believe there's a way to undo that framework absent fraud. And I think, having not found fraud, I don't believe there's a basis otherwise under Sparks and that set of circumstances to otherwise undo the distribution. Have I answered that question?
I think that you have, as I'm hearing you, assuming there's no conspiracy and assuming that that the court was correct in its analysis regarding the parents' legitimate interest in the house, that under Sparks, the net marital asset package as a whole was divided 50-50 or equitably between the parties.
Yes, I believe that the record supports that.
Thank you.
Thank you. Turning to the issue that was raised on behalf of Mr. Taylor, and it's really an issue of law that I'm asking the court to review on a de novo basis. And that is whether the finding that the interest of the parents was a single interest, single 50% interest, with Mr. Taylor holding the other 50%, as opposed to a 1/3, 1/3, 1/3. I would argue that the trial court, which relied upon the Michigan Land Title Standard 6.7, failed to really look at what the deed actually says. That land title standard says that there are several grantees in a deed, two of whom are husband and wife. In the absence of a contrary intent expressed in the deed, the husband and wife are treated as one person and take one share as tenants by the entireties as between themselves and as tenants in common with the other grantees, each who takes one share. We have an expression of that contrary intent right in the deed. The deed here describes the three parties to the deed as joint tenants with full rights of survivorship. Short of coming out and saying, and we really mean it, I'm not sure what more you need to do to show a contrary intent in a deed. And I think really, if you look to the In re Van Connet estate case, which I cited, that tells us that, even though we do have a husband and wife involved in a transaction, it doesn't necessarily create a tenancy by the entireties in this circumstance. And so I would ask the court to take a look at that, and as well as the language of this deed in consideration of the land title standard 6.7 as an issue of law, and find that there was a contrary intent expressed in the deed, which was consistent with the actual uncontested investment by the parties. And with that, unless there are any questions, I will conclude.
I have one question relative to that. Let's assume that your argument is correct. Let's assume that the court made an error in law here regarding the intent of the parties as expressed by the deed itself, by the instrument itself. Does the equitable powers that a court holds in such matters, would that allow the court, regardless of an erroneous illegal finding, to still invade, if you will, the proceeds from that property?
I don't believe it would. I don't believe that when we're dealing with issues of real property and we have very specific requirements for how things are titled and recorded, and recording puts the world on notice of the various interests, to then say, but we're going to allow a court to just set that aside, essentially based on another party's equitable argument, it would kind of start turning real property transactions on its head.
Thank you.
Thank you.
Thank you.
Rebuttal?
As to the response to the appeal, 2 or 3 points, Your Honor. The question that, or the point that Sister Counsel makes about no documentation of a loan, no mortgage securing it, no note, that argument cuts both ways. There's no documentation of a rental arrangement. There's no lease. There's no ledger that the mother kept of rental payments. There's no, by their own testimony, there's no claiming of rental income in their tax returns. So it's not a dispositive argument in and of itself. And Judge Rick, you asked the question about equity under Sparks. I would submit that 10 years of falsely misrepresenting to your spouse that you were repaying a loan for your parents who were acting as the bank, when she specifically testified, had she been told at the time of the closing that the parents were going on the deed, she would not have agreed with him to purchase the home. That would constitute fault under Sparks. Fault is a basis to adjust the equitable allocation of the assets. As to the cross of appeal, I'd say a couple points. Number one, Judge Whitten properly concluded that land title standard 6.7 applied. Sister counsel's argument that the joint tenants with rights of survivorship language modifies the husband and wife designation ignores the conjunction in the express language. The deed says William F. Taylor, Jane C. Taylor, comma, husband and wife, comma, one unit, husband and wife, tenant by the entireties, and Colby Taylor as joint tenants. So the first unit, the husband and wife, are joint tenants with the second unit, Colby Taylor. It's as simple as that. The Van Conant case that Cross Appellee has asserted has a different arrangement of language in the deed. It's distinguishable. I'm happy to answer any questions on that point. Thank you.
None. And Ms. Parker, if you want, do you have rebuttal on the cross appeal?
Just briefly, I would ask the court to just take a look at the Van Conant case, because I do think that, certainly there we did have a husband and wife in a very similar situation. And while the language was a little bit different, adding the designation husband and wife should not in itself, and it's just an accurate reflection of who the parties are, and is often something put in by title companies simply, without any real discussion of whether it needs to be there. I don't think that should be controlling when you have more specific language following that. Thank you.
All right.
Thank you.
Thank you both. This matter is submitted. We'll move on to item number 14, docket number 376031, Mary Freebread Rehabilitation Hospital versus Progressive Michigan Insurance Company.
Please the court, Andrew Osterman appearing on behalf of Mary Freebed. This is our client's appeal. We really bring one issue before the panel today, and it's the issue of attorney's fees. Court knows the trial court granted summary disposition to my client on the underlying merits of the claim, but did not award attorney's fees under the No Fault Act's fee shifting provision. Our contention is that that was error. Under the law, the only way, first of all, the overdue no fault benefits, once it's determined that is the case, it's presumed that the refusal to pay is unreasonable. Carrier like Progressive can attempt to rebut that presumption under common law using one of three ways: establishing an issue of constitutional law, establishing that their denial was based on a legitimate issue of statutory construction, or third, establishing that their denial was based on a bona fide issue of fact. I'd like to address
the young man being relocated from his parents' home, or at least not able to sleep there. I mean, isn't that a bona fide factual dispute that needs to be fleshed out?
I would submit that it's not.
And why is that?
And the reason is this. Progressive, first of all, seems confused about two concepts in no fault law that are distinct: domicile and residence. Domicile is the answer to whether or not they owe the benefits here. And our domicile case law in Michigan is very clear. It's been that way since 2013 and long before that. Every person in Michigan, for no fault benefit purposes, has a domicile. They keep that domicile until the facts exist such to prove that they've established a new one. Which in no fault purposes means you find yourself in situations where oddities like this can occur. Their position that him being evicted from his parents' home may have eliminated his ability to be there legally, but it didn't change the fact that he was still domiciled there. The only way for that to change would be facts that exist under the Workman and Dairyland structure under our common law that would show he established a domicile somewhere else. So I would submit that that issue in the context of Michigan no-fault law didn't need further explanation after they had the facts, which we all heard repeatedly in the case, in their possession when they made the denial. Recall, they received an application for benefits from Mr. Wolbert, identifying the information he was domiciled with his parents. They then took a recorded statement of him where he reiterated his story about living with his parents for 3 years, being evicted, and then functionally being homeless after that. Then they took an examination under oath while he was, I believe, awaiting some criminal outcome of his accident, where he testified to the same things they knew to be true. It was after that point they said, we're denying benefits. So I would submit on the factual question that you raised, their error was in disregarding controlling law on what domicile is in Michigan. So again, the only way they avoid fees is to show there was a bona fide issue of fact, an issue of statutory construction, issue of constitutional law. Constitutional law has never been an argument here. I'll ignore that. There was never an issue of statutory construction that was relevant for their denial. So the concept of domicile, that's the phrase, and that's in 500.3114.1. They don't assert that they're confused under the law about what that term means. They also don't assert that our law is in conflict about what that term means. That term under law, under the statute, has been the same for years. And so I would submit that their argument that there was an issue of statutory construction is really just a dressed up argument that there was an issue of fact. Now, as it relates to the issue of fact, I said much about it a moment ago, but I'll reiterate just a few points. The chronology here is such that they disregarded the notion that a person has a domicile and doesn't get a new one until there's facts sufficiently present to show that that's true. And under the no-fault law, it's not permissible for a carrier to simply ignore controlling precedent when it makes its denial, which I would submit is exactly what Progressive did in this case. And so, you know, the rhythm of the process was the claim is presented, there's facts establishing this kind of strange way this man is living. They take an examination under oath where he reiterates it. They deny the claim on the basis that they don't owe because he's not domiciled, notwithstanding what Grange says about that. Mary Freebed files a lawsuit. They want to then take his deposition again, which the court allows them to do, ultimately resulting in a motion for summary disposition. We heard the same facts from application for benefits to the EUO to the deposition, which is simply this. He was living with his parents for 3 years. They evicted him, which ended his tenancy, and then he began living really a homeless lifestyle in the woods. That is an odd fact pattern, but it is one where under no-fault law, his domicile was and remains with his parent. Now, we cited 2 cases, albeit unpublished, that I think are instructive about how it's the case where if a carrier wants to avoid their obligation to provide domicile relative coverage, as Progressive would be required to do in this case, they have to establish where else he was domiciled. They can't, it's not enough to simply say, well, we know he's not domiciled with our insured. They have to show where he might otherwise be domiciled. And the Farm Bureau case talks about that in a grandparent situation, as does the Auto Club case in a parent and child situation. They never offered any counter evidence because there wasn't any. There aren't facts and weren't facts to establish that he had done the necessary things to establish a domicile elsewhere. So because of that, we submit the presumption of unreasonableness was not rebutted, and the trial court should have given my client the attorney's fees it requested. Ask for remand on that. Unless the court has questions, I'll save just a few moments for rebuttal.
See none.
Good morning, Your Honors. Andrew Malik on behalf of Defendant Progressive. So we are asking that this court affirm the trial court's decision to deny their request for attorney fees and its finding that there was a reasonable basis for Progressive to question the underlying claimant's domicile and to delay payment. The case law is very clear that where there is a reasonable dispute that exists as to coverage or the amount of benefits owed, that an insurer is allowed to contest that claim under the no-fault statute without penalty. And I think in this case, I don't think Progressive was confused about the difference between domicile and residence. I think looking at the definition of domicile from the case law, I think it's clear that it was reasonable that Progressive would call that into question. In Grange, it's defined as the place where a person has his true, fixed, permanent home and principal establishment, and to which, whenever he is absent, he has the intention of returning. And from all of the evidence that we have in this case, the order of eviction and the EUO and deposition testimony, Mr. Wolbert legally could not return to his parents' home, but also he stated that it was not even an option for him to return there. So looking at that definition of domicile, I think it was reasonable that Progressive would say, well, this doesn't fit into that category. With regards to
Ask a question, if I might interrupt you real quickly. It seems to me that when we're dealing with these issues, which we get quite a bit of, as you all know, this act is not the model of clarity. But at what point, as a court, at what point would you say we should focus on whether your clients were reasonable or unreasonable? I don't think any of us, and I don't mean to misspeak from my more learned colleagues, but probably none of us would think that your client's saying, well, wait a second, we have to look into this because of the facts that you just said was unreasonable. But how much time, I guess, is what I'm getting to. That seems to be the crux of Brother Counsel's argument. That, you know, okay, fine, you could look into it. But really, did it take this much time for Progressive to reach its decision? You understand sort of the nature of, you know, this is kind of the gray area that we deal with. What's your response?
Well, I do understand that in some circumstances, well, I think it comes down to obviously a case by case basis, right? When you have unique facts such as this, where someone is saying that they're essentially homeless, there's an order of eviction. I don't think Progressive was wrong to take an EUO and then subsequently take depositions to see maybe that changed. I think that was, in fact, due diligence on Progressive. And of course, plaintiff eventually filed a motion for summary disposition on that issue. But as far as their ability to conduct an investigation as to his living arrangement, I think at some point it would become unreasonable if different facts were appearing and things like that. But in this case, I wouldn't say that it was. I think they're taking an EUO and depositions of all the family members was important so that they knew, okay, it's in litigation now, the facts haven't changed, and we're still not clear as to what Mr. Wolbert's domicile was.
Thank you.
Plaintiff cites Farm Bureau versus Progressive in support of their claim. I think there are some factual distinctions between this case and that case. Again, there being an order of eviction in this case, as well as the fact that Mr. Wolbert testified that he did remove all of his belongings from his parents' home. I would say that this case is more similar to another unpublished case, albeit unpublished case, Member Select Insurance Co. versus Rich, which is a recent opinion from this court, where again, there was a court order stating that the claimant in that case could not visit his parents' home unless it was for supervised child visitation. And in that case, this court held that he could not have been domiciled in that household, and that it was the trial court's duty to focus on the question, or the trial court was tasked with determining whether that claimant was domiciled with his mother rather than where his new domicile was. And again, this is somewhat of a unique situation, but I think from Progressive's perspective and any insurer's perspective, it is more of a focus on, is this person domiciled with our named insured? because that's where the progressive policy of insurance is. As far as now with,
You know, I was thinking about this in a different context too. It, you know, if there had been, you know, rescission or reformation or what have you, you know, because the mother, there was, at least early on in the proceedings, seemed to be some suggestion that there wasn't a disclosure, at least initially, to your client about about the fact that the individual involved in the accident was a member of the household and therefore. But I wonder if after, and this cuts to your client's in your client's favor, I think. I wonder though, if after Progressive would have lost that argument, if mom would have come into court and said, look, I evicted him.
right, and I think that, I mean, obviously hypothetical, but that may have
Right.
been some, right. And I think the last point I would just like to briefly make is if this court is considering a remand, we would request an evidentiary hearing on the issue of the amount of the reasonableness of the attorney fees. We believe we are entitled to that if this court is considering a remand. Unless there are any other questions, I think I covered.
Thank you, counsel.
Thank you.
Rebuttal?
Just a few points.
You mind addressing, if you don't mind, counsel, his answer to my question, which was, you know, basically what do you think was reasonable for you to have undertaken in this case? And he basically said, well, we thought we needed to take the depositions of the family members. Do you think that was unreasonable?
I've got two answers for the court's question.
Okay.
I'll give you first a technical answer. You asked the question.
Well, let me
How-
ask you this before, how would you have defended that criminal?
Well, let me answer your first question. You asked counsel, how long does Progressive have to make its determination? And I'll give you the technical answer. 500.3142 is the statute, which gives the 30-day grace
I'll
period.
sleep with like the no fault act
Yeah.
at night.
Too many
You're like a
no-fault cases.
walking encyclopedia. This is pretty impressive
So-
stuff.
That statute says that benefits become overdue if not paid within 30 days after the carrier's receipt of reasonable proof of the fact and amount of loss. The timeline extends to 90-day grace period in circumstances where the first they learn of it is after more than 90 days has passed since the accident or the claim is presented. So in this case, that would be 30 days. That's the technical answer. That is the grace period our legislature has given, the time in which the investigation should take place. The second answer I would give you is this. The law on attorney's fees is such that the court is supposed to measure the reasonableness of the denial at the point in time when it's made. Now, in this case, we have a fairly clear record about when that happened. The claim accident was in July of 2023. The application for benefits was just a day or two later. There was a review of that, a recorded statement taken, EUO under oath taken, and then on November 1st, 2023, denial takes place. So it is at that point the court assesses under the case law whether that was reasonable. And I would submit to you it was not reasonable. And here are the reasons. Factually, Progressive had the benefit, first of all, of the backdrop of the case law, which is Grange and Dairyland Workman, which has been the law forever in no fault. It's a 9-factor, multi-factor test where the court balances and a Progressive insurer like sitting here should balance facts like where does the mail happen? What does the driver's license say is the address? What's the subjective intent to remain? Where are the person's possessions kept? Where do they sleep? That's how you balance the determination of domicile against the framework of Grange, which is that everybody has one and you don't lose that one till the facts exist where you acquire a new one. Against that legal backdrop, when they made their decision to deny, there was the benefit of under oath testimony on these issues developed by their lawyer. So I would submit that the law is not new to them. They're a sophisticated actor. They know what the standard is on domicile. They had every opportunity to investigate that, and they made their decision after doing so, and their decision as of November 1st, 2023 was not reasonable. So other than that, Your Honor, I don't have more to add.
Thank you.
Thank you.
It's a very interesting case factually.
Thank you both. The matter is submitted. We'll move on to the next case, which is item number 15, docket number 375352, Parker John Serbrook versus Michigan State Police.
Good morning, Your Honors. Attorney Cohen Harkness on behalf of Mr. Serbrook, here today with my co-counsel, Mr. O'Keefe. I know you've read everything, so I will endeavor to be brief. I'm
We're
sure
just moving you along the food chain.
well, I'm sure you've heard that multiple times this week already. So there's just a couple points I'd like to hit on that I think are really germane. I really took issue with with the fact that I don't think the Court of Claims properly address the retaliation claim under C8. As the court's aware, it's a four prong cause of action, and realistically, I think Applee only takes issue with prongs 3 and 4, and whether or not there was an adverse employment action, whether there was a causal relation between the protected activity and the adverse action. In this case, subsequent to our client filing his notice of intent and sending a demand letter, he was immediately ordered to an e-applications unit and a help desk and was basically relegated to a secretarial role. He was given a variety of demeaning tasks, very benign, compiling lists of tow companies. He was given no training. He was answering phones. He was doing things like that. And as this court has held, having a less distinguished title, some significant diminished responsibilities or other specific indices are adverse employment actions. So we submit we met that prong. And as it relates to the causal connection, this court has also held that that may be established through circumstantial evidence like close proximity in time. Well, he got ordered to this unit right on the heels of both the notice of intent and the demand letter. In fact, the day that the demand letter was acknowledged as received, he was ordered to report to this e-applications unit. So I think we hit both of those prongs, and what troubled me is the Court of Claims didn't analyze any of those. And so I think we pled a prima facie case for retaliation. I know that, the response from Applee is, well, he lost his MCOA certification. We had no choice but to send him to this non-trooper role. Well, here's the problem with that. He works for the state police. The state police controlled his return to work. They controlled his ability to train. As soon as he got to the e-applications unit, he said, "Can I participate in firearms training?" They said no. He said, "Can I participate in other training?" They said no. He said, "Well, what do I do to get back in the saddle, so to speak, to become a trooper?" And he got ghosted. And these were all things that were pled in our complaint. And, what troubled me about the Court of Claims opinions, they said, well, he could read the statute or he could read the admin rules and basically discern what he needed to do. Well, not when the state police are, number one, telling him, no, we're not going to allow you to train. But number two, there are two ways that you can become a police officer, not just with the state police, but any police officer. You either go through new recruit training, which is for people who haven't gone through it before, which doesn't apply to our client because he had, or you can do a recognition of prior service program, which is when you've been separated from a law enforcement agency for 2 years or more, and you go through an abbreviated course. Well, he was never separated from MSP. He was on administrative unpaid leave, but he was never terminated. So he didn't fall into either one. So he was understandably confused. And when he went to his command staff and said, "What do I need to do?" they wouldn't respond. But I think what's more troubling is they would not let him train. And so it was our position, and what we pled is basically they put him in this role because they were unhappy with the fact that he had been found not guilty after this prosecution. And they were basically trying to make his life miserable and force him to quit. Now, finally, a month later, they start putting him through training. And after he goes to that training, they send him back to this e-applications unit. So I think we pled a prima facie case for retaliation. I think the Court of Claims erred on that point. As it relates to the discrimination claim, I'm not going to take up the court's time there. I'm just going to say, I think we pled a prima facie case. To the extent that we didn't, I think the Court of Claims was obligated to allow us to amend the complaint. Realistically, I'll be candid with the panel. I think if this gets remanded and reinstated, we're probably just going to run with retaliation claim. But I think we pled a prima facie case for discrimination. I do want to just touch on the amendment. We specifically requested in our response to the motion for summary disposition the opportunity to amend. The Court of Claims didn't address that at all. The Court of Claims didn't find that that it would be futile. They didn't mention the request for amendment at all. And as this court has held, a trial court must specifically specify the reasons for denying leave or it mandates reversal. So I think at the very least, this should be remanded for our opportunity to amend to address any C8 issues that the trial court may have had. As it relates to the C10 argument, so two issues that I want to hit here. Number one is the appellees did not attach any documentary evidence to their motion for summary disposition for their C10. And this was something we raised in the trial court. And again, the Court of Claims didn't address that at all. There was, I will acknowledge, a transcript from a preliminary exam attached to the motion for summary disposition. But that only had to do with a claim that was dismissed in our first amended complaint relating to malicious prosecution. That transcript had nothing to do with either of the claims in the amended complaint. It was not cited in any way. And so, absent that documentary evidence, I think the Court of Claims was obligated to deny the C10 motion because, as this court is aware, the initial burden's on the moving party to show that there's no genuine issue of fact, and then it reverts to us to demonstrate that there is. And without that initial showing, I think the Court of Claims erred. The other thing, Your Honors, that I want to hit is even if there had been that documentary evidence, the issue of whether or not the employment action that we're alleging was taken by the state police against our client was adverse is an issue of fact for a jury to decide. And this court specifically held in the White case that it is for a jury to decide whether anything other than the most petty and trivial actions against an employee should be considered material adverse to the employee and thus constitute adverse employment actions. And so I think that the Court of Claims kind of overstepped its bounds in that regard as well, because that was a factual issue for a jury, especially in light of the fact that there was no documentary evidence. So I'm happy to answer any questions, but I'll leave it there because I'm familiar with all three members of the panel. I know you're always very thorough.
I see no questions.
Thank you.
We have plenty of time for rebuttal.
Good morning, Your Honors. May it please the court, Assistant Attorney General Shelley McCormick on behalf of appellees.
How come you don't have a big pen like Mr. Morton?
Never got a pen, Your Honor.
You didn't get a pen?
did
You
get a
haven't been pinned.
I haven't been pinned.
Wasn't that a college thing? Like
Yes,
if you
it
were
was.
pinned like a sorority, like a fraternity?
I feel like I'm
I
missing.
wasn't a fraternity
Yeah,
guy.
I feel like
They
I'm
would-
missing something
You
now.
are, yeah. I think you
You need to
better.
check into it.
Yeah, I'd get a real, like a wrapper size pen, like this
Yeah.
big, put it on a gold chain and wear it around your neck.
Next time. I
And
come
then
in.
show it to Morton.
Right. I will. I think where else pick up with is the responding to the argument on the C8 motion regarding whether Sherbrooke pled a prima facie case of retaliation. I think what appellant is missing is what is the adverse action? And that's really what the Court of Claims focused on is what was the adverse action? And here, what's pled in the complaint is effective demotion. Those are the words that are in the amended complaint, that he was effectively demoted because when he returned to work, he was returned to what Sherbrooke describes as a civilian position. The E applications unit actually is a mix of civilian and enlisted members. That's actually also pled in the amended complaint, that there were sergeants and lieutenants. So it is not strictly a civilian job, but the point is that Mr. Sherbrooke couldn't go back on road patrol as a trooper. He wasn't MCOA certified. He didn't have the licensure to do that. And so where is MSP supposed to put him? He obviously took issue with the fact that he wasn't being placed back on the road as a trooper. That was an impossibility until he became certified. So I think what's important in terms of the C8 argument of appellant is What was the adverse action? It was he's calling it an effective demotion, but it wasn't a demotion. The complaint also alleges that he remained classified as a trooper the entire time that he was employed, even when he was on suspension. So
Why isn't this a jury question? Whether he was demoted?
he has to prove that putting him back into a role as a civilian is a pretext, right? Like they did that as a pretext. They don't have any other option. They can't do what he wants them to do, which is put him back as a trooper. That's not a jury question. That's statutory. I mean, what appellant's missing is that MCOA's license, they license all law enforcement
It's
officers.
not controlled by the Michigan State
It's not
Police.
controlled by the Michigan State Police, and it doesn't only apply to Michigan State Police members or troopers. It applies to all law enforcement.
What about his requests to assist him in navigating that process? Was there any obligation or retaliatory intent in not helping him along the way?
I don't think that's properly pled, but what I'll say about that is that the amended complaint alleges that he did have some week-long or some period of training once he got back into a role at MSP. Secondly, the statute and the administrative rules make clear exactly what any law enforcement officer who's trying to get recertified, what their job is to do. And we compared it similarly to, I'm a lawyer, I'm licensed. If I become unlicensed and I want to become licensed again, is that on my law firm? Is that on the Attorney General's office to guide me through that process? Or is that my obligation as a lawyer who's the license, who has the license to go and follow the requirements of licensure? MCOA's set those rules and the licensing requirements. Mr. Sherbrooke, it's on him to follow those requirements. And so I don't think that there's any complaint that Michigan State Police or Colonel Grady somehow prevented him from following those requirements. I don't think that the certification process happened quick enough for him. I think that's definitely clear. He he regained a position in December and resigned in April. But to say that that somehow is retaliation on Michigan State Police, it doesn't, there's no causal connection because Michigan State Police doesn't control the MCOA certification. And that's really what the Court of Appeals.
Court of Claims.
The Court of Claims really focused in
Have
on
that issue as well.
in their decision. In its decision, it really focused on who has the authority to certify Parker Sherbrooke as a trooper.
There was nothing on the record then that would suggest that there's any policy or facilitation that MSP historically would undertake with people attempting who've lost their MCOA certification. Is there anything?
Nothing on the record, no. The other
How
point
about
that
this though, counsel? This is and I'm interrupting you and I apologize. But I'm curious because I think, as I understood Brother Counsel's argument, this is evidence of the manner in which the plaintiff was being treated. It may well be that they don't disagree with your argument that obviously MSP has no ability to certify the plaintiff, but the fact that they would not even go so far as to assist him or to work with him is evidence of a bigger issue, which was essentially their retaliatory intent. Why is that? Why is this evidence not relevant to that point?
I don't think that it's on Michigan State Police to facilitate a trooper's certification with MCOs. That's a separate statute that MCOs controls. So this whole argument that he couldn't go back and meet the requirements of this the program's recognition of prior base training experience. So if you were previously certified, there's certain requirements you have to go through, different than if you're a new recruit. Counsel argued, well, he couldn't apply to that. He couldn't perform under that because he was never separated from Michigan State Police. The rules are very clear, and if you read them, they talk about an involuntarily discontinued from employment. So this isn't a question of he has to be separated from Michigan State Police. He has to leave Michigan State Police in order to try to get certified through MCOs. MCOs provides a vehicle for that. And he has to meet non-medical selection requirements, and he has to meet medical selection requirements. And then there's a licensing examination. So this idea that this argument from appellant that, well, you have to, Michigan State Police or Colonel Grady for that matter, you have to help me get through my medical selection qualifications that's governed with MCOs, or that you have to help me get through my licensing examination. I would say it's similar to a bar exam. Is it the Attorney General's office to facilitate me as a lawyer who wants to be relicensed to take the bar, or is that my responsibility?
So your argument is these are all legitimate questions that anybody should have, and they should have been addressed to MCOs because that's one who has the answers, and two, those are the folks who have sole control over this process.
Right, and that's
Okay.
why it was
No duty on my client's part.
correct, and that's why the motion was granted with under C10, because there was no genuine issue of material fact that Michigan State Police couldn't recertify. They couldn't control MCO's recertification, timeline or change the requirements. That was something for Parker Sherbrooke to do. And then so in this case, that's he's upset and thinks that MSP is retaliating because they put him in a role that wasn't a trooper, but they didn't have a choice. They had to put him in a role that was not a
He
trooper role.
wasn't certified.
In terms of amendment, the standard on that is abuse of discretion. And I think it's very clear from the trial court's opinion and order that any kind of amendment would be futile. There's no way to allege additional facts. We also mentioned that there was nothing presented by appellant at the motion stage to say, here's what my second amended complaint would look like. Here's what additional factual allegations would look like. But regardless of that, what I would submit is it's very clear that Judge Patel felt that an amendment would be futile. I mean, if Michigan State Police doesn't control the licensing of Parker Sherbrooke and can't make him be recertified or relicensed quicker, or even do those steps, facilitate those steps, what allegation possibly could Parker Sherbrooke have to show that Michigan State Police retaliated against him for filing notices of intent by not making him a trooper, by not putting him back on road patrol? So that would be my comment for in terms of a response to why there was not leave granted to file an amended complaint. It was because it was futile. I think unless there's any other questions.
Well, good luck with the pen.
I'm going to look into it. Judge. Thank you very much.
Thank you.
Piqued my interest, Your Honor. What fraternity?
I was not in a fraternity.
Oh, you were not. I'm sorry. I thought
No.
you said you were.
Oh,
Okay.
gosh, no.
Okay, fair enough. I just, very briefly, Your Honors, I just want to be clear. Appellant is not saying that it was MSP that certified Parker Surbrook. We don't dispute. That is M. Cole's bailiwick. Is it a division of MSP? Absolutely. But they set the various requirements and standards. The problem here is MSP, this was not an individual who, Applee wants to put it all on Mr. Surbrook. This is not like a first timer who goes out and decides, hey, I want to be a police officer. I'm going to go to the Mid-Michigan Police Academy, go through that and hope that I get hired on with the department. When you're a state trooper, you go through the Trooper Academy. In this case, MSP controlled his return to work and they controlled his ability to train. And we specifically pled when they brought him back. He said, can I participate in firearms training? No. Can I do this other training? No. Well, what do I need to do to get back to being a trooper? And they ghosted him. And because, and I respectfully disagree with Sister Counsel. I think he fell into an area where neither the first time track applied or the recognition of prior service applied. And that's why he asked his command staff, what do you want me to do? When can I start training? And they wouldn't let him. And they put him in this position and intentionally gave him scut work to basically make his life miserable to try to get him to quit.
That's a word I've never heard before. Scut?
Really?
Yeah. Have you? I'm not familiar. What does it mean?
We'll just say low end work.
Oh,
Maybe.
okay.
Work that would. I don't think there's any question that what they had him do was work that was
SCUT?
correct.
Huh.
It was
We're gonna have to get up.
it was
there.
work.
We're gonna have to look that up.
Okay.
Right.
All right. I've used it in what is that, categories? But in any event,
I don't know what that is, but I'm old.
Nate, I'm going to profess ignorance. I don't know this, and if it's in the record, I'd love you to point me to it. But you've mentioned several times, both the first time you were up and now, that they wouldn't let him train. Is there a requirement that you can't shoot your gun or train because you're not MCOA certified?
well, so I guess
Where does that prohibition, as you understand it?
so because he's employed by the state police, any training that he does has to be done through the state police. So whether it's
Hear you.
in-service training or training through the academy, he can't go out to a separate academy or outside of he has to do training through the state police.
But my question is, I mean, just as we wouldn't necessarily let someone who does administrative work show up and shoot a gun or, engage in other trainings, my question very pointedly is, do you know if there is an MCOA certification requirement in order to participate in that training? That is my question.
My understanding is he has to meet the basic eligibility requirements, which he already had because he had been previously employed by MCOLs.
Okay, you don't know whether whether included in that is the requirement that he be certified.
I think, if I'm understanding your question, I believe the MCOLs certification, so to speak, is what you're referring to. I think he needs to have his he needs to have that training in order to move on to the next step. But I guess my point to the panel is they wouldn't let him.
But I think what she was asking was,
Maybe I'm not
Does
picking up
he-
what you're putting down.
Please interpret.
was he, and I think it's a very good question. I'm glad she asked it. As I heard it was the fact that he was was not MCOL certified prohibit him from participating in this training?
No, that would be my response. No.
Was that what you wanted to know?
That was what I wanted
thought
to
so.
know. Yeah.
And the only other point,
So let me ask this.
Sure.
What, and I guess it's not even in this record, but so I think it was the amount of time that he was off because of the criminal charge and then the
Correct.
delay in the trial and then the acquittal and all of that. That's what got him decertified?
So the lack of time being able to essentially work as a police
Correct,
officer is what
correct.
caused, right?
For whatever reason,
Sure.
okay, then is counsel not correct that it's his responsibility to get the certification before they can put him back on the street as
Well,
a certified? I understand their point. You can't just say, oh, you're not certified to be a police officer, but that's okay. Go out there and
Sure,
and
and
do that.
and I understand your point, Judge, and so the point that I guess I'm making, my response to that would be is he can only do that through the state police. He asked to do that.
And that's where I think we're having a disconnect.
Okay,
MCOA certifies them. Whatever MSP is doing does not factor into MCOA's recertifying.
so the training that he does to get MCOL certified is with the state police. It's not like there's some separate, like, it's not like he goes to the MCOL's floor of the state police and participates in some training and then comes back and does different training with the state police. It's all part and parcel of training with the state police.
So why didn't he just call MCOs to begin with?
Well, he went to his immediate command staff.
Again, I think counsel's point is valid here. If I lost my law license at some point, I wouldn't call the state bar and say, you know, or call, you know, my chief judge and say, hey, help me do this. I think it would be on me to follow through on that process
And-
to become relicensed.
And he was trying to, Judge. I guess, and maybe I'm not making it clear, but he can only do that training at the state police training center.
Yeah, that's what you're saying, but I don't know where that is in this record. Where the evidence is
Well,
of that point in this.
as, I
record.
mean, we played in several places that they wouldn't let him train.
You pled it, but where was it in answer to the motion? Okay.
It would have been, it's in there. I can tell you that.
Okay.
The only other, I mean, I guess what I would say, Your Honors, is
Trust me, the car runs brilliantly.
you know, and I get the point that Your Honors are making as to, is it incumbent on him to get that before he can go and do the training? But I guess what the best way I can say it is they had total control over his ability to do that. They said, report back to work.
All right.
I've exhausted that point.
Yeah, I think we're beating the horse.
Okay. The only other thing I want to
here.
mention that I think is telling in this case, Your Honors, is our client was acquitted of the criminal charges in August of 2023. They made no effort to bring him back to work and had no concerns of him continuing to be on unpaid administrative leave until they got the notice of intent and the demand letter. And right on the heels of that, they said, get back here, get in this e-applications unit. And that's when it started. That's when they started trying to drive him out because they knew they wanted him gone. So I'm happy to answer any other questions, and I promise I won't try to convince you any further of the MCO's licensure issue.
I see no further questions.
Thank you, Your Honor.
Thank
It's
you.
very well
Thank you both.
briefed by
Yes.
all.
Yes, and that matter is submitted. We'll move on to the last item on the 10 o'clock call. Item number 16, docket number 370064, Robert Longgrave versus Michigan Department of Corrections.
Good morning, Your Honors. May it please the court. Adam Taub on behalf of plaintiff appellant Robert Longgrave. I intend to be very brief. Obviously, there has been a great amount of development in case law on these issues since the
Yeah,
briefing
I
closed.
mean, right. You did ask us to hold it.
And we don't.
And we
do that.
don't.
Yeah, I would, implore this panel to withhold its opinion until the Supreme Court weighs in.
But we have a published opinion directly on point.
You do.
And
I don't have a way around that, Your Honor. I acknowledge it.
And we don't know if the Supreme Court's gonna do anything.
And I think a couple of members of this panel were on that.
Correct.
Correct. I fully acknowledge that, but as I said, that's
I
why
mean,
I
Yes.
just want to be
get it.
brief
Yeah,
about it.
And, right, and look, we don't know what is going to happen in the Supreme Court.
Right.
So,
I just
I
wanted to
mean,
point
we
out, I
just gotta
feel,
keep these going forward. You know what I'm
Yeah.
saying? And it's, if it comes back to us, it'll come back to us and in
Right.
spades, apparently.
Yes, yes.
well.
So.
And let's be honest, they need the work.
All right, well, thank you, Your Honors. I won't keep your time.
Yeah,
Thank you.
yeah, we all recognize what's going on.
I will also be very brief, Your Honors, because all of you have ruled on this issue before. Basically, I'm Assistant Attorney General Aaron Graham.
Thank you.
I don't have a pin.
I'm sensing a clear issue here involving gender.
I do have an Attorney General badge.
Oh, wow.
So we got
Which I'm
that.
sure you're smart enough to never flash.
Nope, nope,
Unless
it
you
stays
wanna
in my
end up
work
on the
bag.
6 o'clock news, flashing your badge.
Absolutely, Your Honor. But yeah, there are no unique circumstances in the
But
fact.
now that you've done that, we have badges too.
That's
And once
amazing.
again, they're puny little things. They're like this freaking big. They go on a keychain.
Oh,
They're
wow,
not
yeah.
an actual, I don't, they're like
Yeah.
something you would give a kid, like that goes to the police department and they go, hey, Billy, you're a junior police officer today.
Yeah.
So we just get short shifted on this big time.
I was gonna say, mine
You got
is
a big
regular
badge,
yeah,
potentially could get a big pin.
yeah.
We don't even have the potential. Wow. All right.
But just to say, Christie is binding, the Hudson Conflict Panel is binding. There are no unique circumstances in the facts or history of this case that require a different analysis or result. If you see anything differently, I'm happy to answer any questions. Otherwise, we ask that you affirm the decision of Branch County Circuit Court. Thank you.
Thank you very much for your time. Appreciate it. Thank you both.
All right, and that matter is submitted. Do we need a break? All right. We're going to take a short recess. All right. Welcome to all of those here for the 11 o'clock call. We'll just go through the rules as they come up. And for right now, we're going to call item number 17, docket number 371-069 and 371-147, Jill P. Mitchell versus Brian J. Mitchell. Was Ms. Mitchell checked in? Okay, all right. She was endorsed for oral argument and it is now just past noon. So this matter will be submitted on the briefs and we'll move on to our next case. It is item number 18. It's a consolidated case, docket numbers 375-438 and 376-413, Karen Lynn Grassmeyer versus Ronald Lee Grassmeyer II. And do we have Mr. Falk?
He's right there.
Oh, yes, nobody showed up, so it's on brief, so. I think it's Ms. Speaker. Go ahead.
Good afternoon, Your Honors. Lisa Speaker. For the appellant father, Ronald Grassmeyer, I would request to, this case is a divorce case, that divorce trial with 4 minor children. The trial court awarded primary custody of the 2 older children to my client and allowed them to continue to attend Whitehall schools. And he awarded primary physical custody and parenting time to the mother for the 2 younger children and had them switch schools from Whitehall to Hudsonville. The focus for my argument today is really going to be on the 2 younger children and their custodial situation. The first issue I wanted to address with that is the trial court's decision to set aside the party settlement agreement. So as you already know, this case had a long history before the parties reached a settlement agreement because it started for an entire year in Muskegon County. But then once it was dismissed and refiled in Ottawa County, the parties eventually came to a settlement agreement in December 2023. That settlement agreement did a bunch of things, including addressing property issues, support and all that. But most significantly, it had the parties sharing the custody of their children and had them continuing in the Whitehall schools. For purposes of today, for the argument today, we're going to just assume, we're going to not concede, but agree like with the judge's analysis that my client committed fraud by not disclosing a quitclaim deed that happened afterwards. We challenged
He
that
bought
in the.
lot next door and he was going to build on
Pardon?
that. He bought the lot next door. Is this the one?
Yep.
Yeah, the quitclaim deed for the lot next door, which the party, he had been using and building stuff on for a long time before that. So for purposes of our argument, I just want to focus on what the judge did when that situation came out. We did challenge the trial court's underlying finding of fraudulent non-disclosure in the brief. But for purposes of today, I really wanted to focus in on the children because what the judge did was that he threw out the entire agreement, not just throw out like the fact that he had a property division that maybe, okay, well, if wife, you say this quitclaim came up after the fact and the husband failed to disclose it, let's go ahead and redo the property division, or let's go ahead and award the entire lot 6 to wife instead. But the judge threw out the entire agreement, and even over mother's objections in court in January 2024, she did not want the custody portion and parenting time portion of the mediated settlement agreement to be thrown out. And frankly, the parties had been through a lot by that point. The case started originally in March of 2022. Now we're in January 2024. So we're almost to the 2-year mark where they've been fighting over
Going
custody.
backwards. Let's get to the point.
So the point is that the judge had other alternatives available other than throwing out the entire mediated settlement agreement. And so the error I want to focus is on the fact that he threw out the parenting time and custody portion of the agreement, and that should have remained in place. Now, I did want to point out, and I'm almost done with this issue.
Is the basis of that claim that the court doesn't have to approve an agreement regarding parenting time?
So but that was the next thing I was going to address, Your Honor. In Brother Counsel's appellee's brief, he made the comment multiple times, well, the judge, the judge decided it wasn't in the best interest of the children, the parenting time and custody agreement that the parties had agreed to. He did say that in, I believe, January 2025 when he issued his opinion. But when the judge made the decision to throw out the entire agreement, I went back and checked because I'm like, am I completely losing my mind? I went back and checked everything. I checked the motion that mother filed. I checked the hearing transcript from that hearing to set aside. And I checked the trial court's order and even checked some things that happened shortly after that. And there's no mention of the fact that he's throwing out the entire thing because he doesn't believe it's in the best interest of the children. That didn't come up until 15 more months of litigation and 16 days of trial. And then in his opinion, his custody opinion after trial, he mentions like, oh, well, also, I didn't think it was in the best interest of the children. So
Then the question, counsel, was does the court retain the right to approve a custody agreement? It's a simple yes or no.
yes, Your Honor, he
All right,
does.
thank you.
But he didn't do that. He didn't analyze that at all at the time he threw out the settlement agreement. So moving to the custody.
He has the power or he has the authority. What difference does that make? Does he have to say, I'm doing this because, or can he just do it?
I mean, I would say that he should have at a minimum, if he was going to say, I'm going to disagree with both parties who want this custody and parenting time agreement to be in place without even addressing the fact that he was throwing out the baby with the bathwater, basically. He didn't address it at all. And so I think there has to be.
Did he not address it? Didn't he address it by not incorporating it into a policy or into a judgment of divorce? Isn't that addressing it?
He addressed it after 16 days of custody trial.
So I don't understand what the error is here.
The error was in January 2024 when.
But based on what? You've conceded that he has the authority. Yeah, I understand what your argument is, counsel. You're saying, well, he shouldn't have done this, he should have done this, he should have been laser focused, but yet you've conceded he has the authority, so I'm kind of scratching my head here, wondering what it is you want us to do.
So going to the custody issue that we raised, we want this court to reverse the trial court's decision with regard to the two younger children, and which gave primary physical custody to mother and had them switch schools from the school they had been in for their entire lives, to go to Hudsonville schools instead of Whitehall schools. And so we're asking the court to reverse that decision, which was why I mean, putting aside the mediated settlement agreement, we still separately raised the custody issue of the two younger children. And we challenged several of the best interest factors that the judge analyzed as against the great weight of the evidence. And I didn't want to
You
spend.
know what an uphill battle that is, right?
Yes, Your Honor, it's always an uphill battle. But that doesn't mean I haven't won on that issue before. And that doesn't mean I'm not going to continue to raise it when I think the facts are appropriate to do so. So in this
I don't
case,
see it in this case, just to make you aware, you seem to suggest that there were just a couple of reasons why custody was awarded the younger children. I think the mother, you have the father, right?
correct, Your Honor.
And that's not what the record revealed at all. The record revealed a continuous pattern by your client of demeaning the mother in front of the children, such that, at least in my mind, after reviewing this record, there was a serious concern I had whether the reason why the two older children were physically attacking their mother wasn't based on solely almost on your client's actions.
So in our brief, we acknowledged the things that our client said that
Not all of them.
well, I combed through the record and came up with a
So did
list.
I. I'm
Okay.
telling you, not all of
Okay.
them.
But then we also had a list of the things that the mother was doing that would definitely cause the children to, have more
Well, the
difficulties.
difference here was, at least in my opinion, was mom accepted at some point, you know what, I told the kids that the reason the marriage went south, so to speak, in colloquial terms, is because dad had an affair. I made a mistake. Whereas your client never seemingly that I could find admitted making a mistake as to some of the really nasty things he said, and allowing one of your own kids to physically attack your spouse, whether it's that's pretty serious stuff. I was surprised. I wouldn't have given your client custody of any of the children, to be candid, but I'm not going to reverse them, just to let you know. But anyway, go ahead, make your argument.
Well, I'll just be very brief, Your Honor, about with regard to the two younger children, about how my client was better at managing KG's disability situation and the behavioral issues that arose from his disabilities. And there was evidence from several non-party witnesses and professionals who agreed that dad did a better job of managing the situation with KG. And then with respect to LG, the youngest child, there was so many situations where that child was running away from his mother's home, trying to get back to Whitehall, and father kept on having to redirect him. And in a time when I think there was a time where his parenting time was suspended temporarily. He couldn't pick up his son and bring him back to mom's house, but he arranged for somebody else to do that. So he kept on trying to, yes, there are things that he did wrong. I'm not trying to hide that fact. And I think that's why we put the details that we did in our brief about where he did things that he shouldn't have. But at the same time, when it came to where the children wanted to be, where they wanted to go to school, both parents love these children. But at the end of the day, there should have been at least, a more equal parenting time situation, or something that would have allowed the boys to stay in the Whitehall schools. And so with that, we will reserve the rest of our 3 minutes for rebuttal. Thank you.
May it please the court, Alan Falk on behalf of appellee Karen Grassmeyer. Having heard Judge Borello's remarks and understanding he doesn't speak for the full panel, I don't want to snatch defeat from the jaws of victory, and you have other cases you'd like to hear. So I really don't have a lot to say here.
That would be a wise move.
Yeah, I agree. I would just like to note that opposing counsel has made no mention of the standard of review for any of the arguments she made today.
Well, I think Judge Borello has indicated that he was fully aware of what those standards.
Okay.
are.
And I think to
we
her
all are.
credit, she said, I know, but I'm not
Okay.
gonna stop.
Yeah.
You know, I'm aware, but you know, it doesn't mean I can't bring it. And she's absolutely right.
Right, she is right.
But you know,
She knows the law.
right, the children are going to a fine school as far, you know, there's no argument that the school to which the children are actually attending, the younger children, is in any way inadequate
Efficient.
or deficient or something like that. So
A terrible case, I'll be honest.
it is. It's very
It's
unfortunate.
not something any of us like to see.
Right.
So unless you have any questions for me, I'll not
Thank
disturb
you
you
very
further.
much.
Thank you.
As always, it was a good job on the
None.
brief. Thank you.
Okay.
Yeah, you're the next one
You're-
too.
are- Oh. Are you endorsed?
Yeah, she's endorsed.
Oh, you
Yeah,
are.
because it's a combined
Oh, yeah,
judge.
it's okay.
It's a consolidated, excuse me.
All right, thank you. We'll move on to item number 19, and it is a consolidated case, which is 375-799 and 375-800 in Ray Klimp minors. And we have Miss Pellegero by Zoom on the first one, and then we have Miss Speaker on the other.
While we're waiting for Ms. Pellegero to come on, so you know, for our time, Ms.
Okay.
Pellegero's arguing first.
Okay,
And we assume that we only have 15 minutes together, so,
okay, perfect. All right.
Good morning, your honors. I made it in.
Yes, we hope you're feeling better.
Thank you very much, and I do appreciate the accommodation for the Zoom hearing. And Judge Borello, I do have a pin. It's nothing like yours, and let's not get me started on dogs and cats. I've had 14 of them in the last 18 years. So, I am Evelyn Calagero, and I am here on behalf of the appellant mother, Jessica Klimp. That last case didn't have very pretty facts, and this one doesn't either. But I believe the things that are, and I think those facts drove what happened with the deprivation of the parents' parental rights here. They were never advised from the beginning that this was going to be an aggravated circumstances case. So DHHS just defied any kind of a statutory or constitutional obligation to the parents to provide them with service plans and to provide them with any kinds of other services other than video parenting time to help them reunite with their children.
What services do you think your clients needed to know to not stick their kids in a closet and to continue to have them in diapers to the age that they were and to have them emaciated to the point that they were? Do you really think that was a lack of classes issue?
It wasn't a lack of classes. However, there are services such as supportive visitation that would have provided hands-on help. And especially if they had been brought to Michigan to attend these trials in person rather than being stuck in a jail in Tennessee.
Ms. Gallagher, they weren't stuck in a jail. They were arrested for child abuse.
That's
these minors.
Judge Leonard, you're right.
So
You're right. And I happen to have a problem with being too direct sometimes. But they had been arrested, they were in jail, they were awaiting trial, and the DHHS never made any efforts to bring them to Michigan to be in a Michigan jail to participate in any of the trials in person.
How would they have done that exactly?
They would have issued the habeas corpus writ. Michigan State
On
Police
what
would have.
basis? The state of Tennessee was prosecuting them. The state of Tennessee made very clear that they were not going to participate or allow for any transport. So I really don't understand the basis of this argument. I mean, first of all, just the cost factor alone would have been fairly substantial, but even putting that aside, saying that due process outweighs the cost, it wasn't as if your clients were denied an opportunity to be heard. The trial court, it seems to me, bent over backwards for them, gave them Zoom meetings, gave them breakout rooms so that they could communicate with counsel. Again, I don't understand the basis here. So enlighten me, please.
I believe that Ms. Speaker would be able to speak more cogently to that issue at this point.
All right. We'll wait for her. Go ahead. I'm sorry.
Do you want to move on to a different issue?
Well, one of the things I wanted to discuss was this finding of aggravated circumstances. The only time that DHHS is not obligated to provide services to the respondent parents is if there is an actual judicial finding of aggravated circumstances. And that came up in Walters and also in Barbara Espinosa, where there was nothing in this record where until the disposition came up that the court noted anything about aggravated circumstances. In fact, the initial orders all stated very clearly that the DHHS was supposed to make reasonable efforts to reunify the family. And it wasn't, it was, yes, the two children, the two adopted children, TAK and MAK, they were the ones that were treated horribly. I'm not going to hide that. But the other five, there were really no allegations of misconduct against those children that would have justified no services. There's nothing in there that said there's aggravated circumstances here. And Walters, this court's been very clear in the last several aggravated circumstances cases it's had that without that expressed judicial finding that aggravated circumstances exist, the department must make reasonable efforts. And that could have involved psychological evaluation of the parents while they were in the jail. It could have involved parenting classes while they were in the jail. In many jails, it depends on how much longer they have to stay before they become eligible for services in that jail. But there really wasn't even any communications, especially when it comes to the idea of, okay, let's put together a case service plan. Let's see what you need, what we can do for you while you are there in the jail, what you can participate in. There was nothing like that. There was no parent agency treatment plan, and any of those plans that were actually made did not get to the court until after the rights were terminated. They got to the court in July, May, and June of 2025 following the termination of parental rights and not before. The statutes clearly require these reports to be available to the court 7 days before review hearings. There were no review hearings during this process. And even had there been, there should have been case service plans, updated service plans, parent agency treatment plans. If you look at NRA MJC, that was reversed because the parent had no input into any of the service plans that were provided for her. So, excuse me. The court rules are very clear, 7 days before review hearings, that these reports must be in. And it just appears that because the participants in this trial saw the parents as, I suppose, evil people for having treated two of their children the way they did, everything else went out the window.
All right, I don't know that I agree with that assessment of this record, but why don't we turn it over to Ms. Speaker?
Thank you, Your Honors. Lisa Speaker for the appellant father, Jason Klemp. I did want to address one of the questions, and I think Ms. Kelledge's sister counsel tried to address the reasonable efforts. I did want to add in with respect to TAK and MAK, the children that they were, the reason they were in jail, the reason that we had the whole case was because of the treatment of those two children. Without that aggravated circumstances finding, the reasonable efforts that could have been provided regarding those two children was, you know, if there were behavior, these children had come from a previous termination from an abuse and neglect. And to the extent there were behavioral issues that, you know, if they were handling those behavioral issues improperly, then they could have had classes about how to deal with behavioral issues and the growth issues. The children were small when they came in to their home to begin with. But then moving to OAK and KAK, so we have the judge separated the children and looked at them all. Here's the 3 biological children. There was an adult child as well, but here's the 3 adult minor children. I'm sorry, the 3 minor children biological, and here are the 4 adopted children.
Right.
The judge made no effort to distinguish when there was very clearly what was going on in that house. With TAK and MAK was very different than the 2 younger children. The 2 younger children were very much aligned with how they were treated as the biological children. They were not abused or neglected in any way. And so I guess I don't know what the.
Well,
What-
that's not what the record seemed to indicate. The record seemed to indicate that they were suffering from severe psychological trauma and that they had participated in some of these actions against their siblings on behalf of their
And
parents.
saw them as being justified.
Right. And also saw them as normal.
Correct.
And I don't know that that was different for the biological children. I think, you know, I'm not condoning the behavior. I'm just saying the judge put the 2 groups and put 2 different camps and drew a line in the sand because 2 of them happened to be adopted. And I don't know that it was anything different with the 3 biological children as well. So at a minimum, for as far as reasonable efforts for the 2 youngest children, there could have been, you know, more efforts to have that virtual parenting time. We don't love virtual parenting time, but the state of Michigan was like, well, we don't want to have to spend $22 for them to have a phone call longer than 15 minutes. You know, it was very much about like, they didn't want to spend the money so that we could help retain the relationship with basically all 5 of the kids that were not the ones that were having, you know, with the behavioral issues and what we're talking about with MAK and TAK. So that brings me very briefly to because Sister Counsel already addressed because of the questions of the court, she already addressed the in-person appearance and the fact that they couldn't be in person. I and I'm sure Judge Burrell, I'm sure you'll correct me if I'm wrong, because I don't remember exactly, but my recollection was that our DHHS people were telling the court that, hey, Tennessee doesn't want to cooperate. I don't remember that there was anything in the record where there was something from Tennessee that told us that was true. But one thought that we had, and we put it in the brief, was we know they did all these writs. They did writ after writ after writ of habeas corpus to get the parents to appear by Zoom. Well, look at the writ form that they use. It has a place to have in-person or virtual appearance. It also has a place to say what the hearing is for. So I get that there is a criminal case going on in Tennessee, that they have been charged criminally and there's a pending criminal matter. But in not one single one of those writs of habeas corpus, particularly the ones that were issued before the adjudication trial, then before the termination trial, does it say like, hey, let's just try to do a writ of habeas corpus to have them come here in person, tell the court in Tennessee what it's for.
Case says that the court was under any obligation to writ these people to Michigan in order to satisfy their due process rights. That they had to appear in person as opposed to by video conference. In fact, doesn't the case law hold just the opposite?
Don't we have a court rule
That specifically deals with this
with
issue?
incarcerated parents in custody
Yeah.
and allows, and well, obviously, even before the days of Zoom, telephonically, right? So they got the Zoom appearance. I mean,
Which is better than just a phone.
I mean, I agree it is better than a phone. There's no question about that, Your Honor. But I think
You have a case, I guess, is.
if we have it, it's in the brief. I don't recall one offhand. So I apologize. And if we don't have a case, then we don't have a case. But I think we put whatever cases we could find. There just weren't a lot of cases. I think we cited one unpublished case in our brief that maybe helped out a little bit, but I think there just hasn't been a lot, especially with the court rule change that happened in the past few years about.
You know, the irony though is not lost on us that somebody on Zoom is making an argument that putting these parents on Zoom violated their due process rights.
Now, if you recall from our brief, when you're asking to appear for a trial, you don't have to have a reason why you don't want to why you don't want to agree to Zoom. But they did provide reasons, especially for the adjudication trial where they were going to be in their orange jumpsuits. And the communications, like being able to hear, the equipment wasn't necessarily the best for them to be able to hear, and vice versa. From Zoom to the courtroom in Northern Michigan. But anyway, moving on just really briefly, and I sort of partially touched on it earlier regarding anticipatory neglect. So the judge didn't think there'd be anticipatory neglect for the 3 biological children, but did for some reason think there'd be anticipatory neglect for the 2 youngest adopted children. And our position is that, okay, we understand the doctrine of anticipatory neglect, that if it's how you treat one child is how you're going to treat the others. But the evidence in this record is contrary to that, because it shows that the 2 youngest children were not being treated differently than the 3 biological children. And there is case law to support that. You have to look at how they're being treated. And here we actually have evidence to the contrary, that they were not being treated the same as TAK and MAK, that those 2 adopted children were being treated very differently from witness after witness than all the other kids in their house. And I think, as we say, quoted in our brief or cited in our brief, the LaFleur case and the Kellogg case both talk about that. When you have anticipatory neglect, you need to look at the children to see if there's different situations, and they were differently situated here. And so
they were adopted and they abused the older adopted children. And what's to say that once those kids were out of the picture, it would be different with the younger adopted children, and the older children were placed with grandparents, is my understanding. Right?
they were, I don't think they were all in the same home though.
And that's the reason, and these
That was the
children
difference.
were not.
Right.
Correct. I think that's why the court treated
The
them
guardianship,
differently.
right? Rightfully, it obviates, at least the trial judge thought so, the need. So I'm not certain that wasn't the key factor here, as opposed to what you're suggesting. seemed to me that seemed to be what the judge relied on, was the fact that the other children, the biological children, were in a guardianship with their grandparents.
Well, that would go to the best interest, Your Honor, not the anticipatory neglect issue.
understand.
Yeah. So I think with that, and we did challenge best interest as well, but basically for the same reason, because the judge didn't look at OAK and KAK separately, about their best interest and then how they integrated with the rest of the family. And there's no evidence, like, I think what Judge Letica just said about, well, how do we know that with the two older adopted children out of the house that they wouldn't all of a sudden start treating OAK and KAK differently like they had with the other children. But I think we have a whole record of evidence that, you know, when MAK and TAK came into the house, there were behavioral issues and they had been in the house for a while. It wasn't just like, oh, because all of a sudden they turned, 10, they're going to start being mistreated. I think the children had come into the house at young ages, both of them, and it just doesn't make any sense based on the record and the evidence that all of a sudden, if this family were to be reunified with the biological children and the two youngest adopted children, that they would all of a sudden start treating the two youngest children differently than they ever had. That it just does not, defies logic, I guess. So with that, I don't have anything else to add.
If I could, I just want to say to both counsel that this is a difficult case to handle, but I very much appreciate the two of you taking this case because frankly, in this area of law, and I speak only for myself, I find many of the attorneys who appear in these cases to do just a horrific job representing their clients. That was not the case here, and I very much appreciate your dedication to your clients and for making very, very good arguments on behalf of people who I don't think would have otherwise had even anywhere close to this level of representation. And I do appreciate it. Thank you both.
We appreciate it.
Thank you, Your Honor.
Thank you.
I was just going to, the rule about party who does not consent to the use of video conferencing to take testimony from a person at a termination of parental rights hearing, that's MCR 3.904B2. So, and my Zoom appearance is very different from a Zoom appearance between an attorney-client, with the attorneys being in the courtroom and the clients being on Zoom. It's really difficult to nudge the attorney and say, hey, let's do this. I've been doing trials in Calhoun County, and I've also got an accommodation for Calhoun with the Zoom issue. And it does get difficult to do the back and forth between attorney and client without stopping the proceedings and then going back to them, and especially in front of a jury as this adjudication trial was. So, but thanks.
Point made. It was an off the cuff, was being more humorous than anything else. I understand the difference, certainly.
And I thought about it too. I thought, oh, how ironic. I'm arguing about Zoom and here I sit behind the camera. So, but thank you, sir.
All right, thank you. Thank you both. This matter is submitted. We'll move on to item number 20, docket number 376665, in re Dornbos minors. And we have two arguments on Zoom.
Good morning, Your Honors.
Good morning.
So Judge Barolo, you helped me discover a new benefit for participating remotely, because during the break, I went and got my section pin. It's over here.
Hold on.
Hang on.
Okay, sorry. I forgot that he was appearing remotely as well.
Go ahead.
Go ahead, Ms. Schmidt. I'm sorry.
No, I'm sorry. I didn't remember. Lisa Schmidt appearing on behalf of Adam Dornbos. I just was saying, Judge Barolo, you gave me a new benefit for participating remotely because I was able to go get my pin during the break so I could be part of the pin club.
See, you've got the Morton Big Pen. I'm
That's
glad to see
it's
that
the
a
family
woman
law
got
section
one.
pin. Yeah,
Oh,
it's the family law section.
Section, okay.
So your honors, we're just lining up the difficult cases one after another this morning. I think we've got three core questions in this case. The first, and I think the most thoroughly briefed, is the effect of the no contest plea as the primary and almost sole support for termination statutory grounds. I feel like that one's been very well briefed, so I'm just going to move past it, but I think it is one of the core issues. The second issue, and I think the one that perhaps warrants the most argument today, is how in re mota should be read in conjunction with in re Kellogg and in re LaFrance, because in re mota presumes that abuse is abuse, while Kellogg and LaFrance require an individual showing of a reasonable risk of harm to that particular child. So, your honors, I'd like to take a look at the statutory language that all three cases are interpreting to suggest that we cannot read mota in the broad way that brother counsel has, and that we still must have that individualized finding. Your honors, we're looking at 712A.19b, section 3b, and specifically B subsection 2. So in 3b, the language is the child or a sibling of the child has suffered physical injury or physical or sexual abuse. But then B2 only relates to the reasonable likelihood that the child will suffer injury and abuse. So the or a sibling is no longer there. It is only the child for whom the rights are being terminated. And again, under subsection K regarding the actual termination, it says the parent has abused the child or a sibling, but then it says, and there is a reasonable likelihood that the child will be harmed if returned to the parent's care. Brother counsel suggested an alternative grounds for termination being section M. Once again, that section says that it has to relate to the child, not the sibling of a child. The sibling of a child language is missing. So I think that the statutory language, the plain language in that statute, while technical, only allows for the sibling to be considered in regard to the abusive act that gets them into the court, and not for that reasonable harm finding. So now we get into the anticipatory neglect, right? I should stop and say I'm going on and not listening to you if you have questions. No. Okay, so far so good. So now we say, well, what about anticipatory neglect? Because we know that it is probative evidence that the way that a parent treats one child will affect the way the parent treats other children. But as my boss was telling you in the last case, we have to consider differences. And here, there's a lot of them, right? We're dealing with two boys who are biologically related to the father, whose rights are being terminated based on sexual abuse, alleged, and I have to say allegedly, because once again, it was a no contest plea. There was never any proof on the record that it occurred that was not hearsay. Allegedly performed a sexual abuse act towards an adopted stepdaughter who he had no relationship to around the time of the adoption, by the way. So that's, I mean, we're not justifying this abuse, but it is another distinguishing factor. So we've got extensive cases, many of them unpublished, that say that probative evidence on its own is not enough. It does not establish the clear and convincing evidence to terminate. So because of that, I think we need that individualized finding with regard to the kids. The referee himself said this is a murky issue with regard to the two youngest, and I think that it needs to be reversed because it wasn't there. I'd like to go ahead.
You could, Schmidt, can I direct you real quickly to an issue that popped up for me?
Sure.
I'm very troubled by the lack of review, and I know you raised the issue, obviously. One of my colleagues, I won't say which one, actually did the math, and I think it's like 28 seconds that it took this trial court to review the record and issue its opinion.
Well, Your Honor, you definitely went right where I was going next. I absolutely agree that there is very little more that could be done to show that this was a rubber stamp of the referee's decision, and that is a due process violation by all means. There was no way that our respondent could have inserted himself in time to get the judicial review that he was allowed. He didn't even know it was done until it was over. So I absolutely agree with you, Judge Borello. That is a violation of due process. He was supposed to be allowed to have judicial review, and the judge didn't even bother to, like you said, 28 seconds. How much of the review is he going to be able to do? Especially since the referee never prepared the written report that was required. There's no factual statements that this court could have reviewed. It's a 2.5-hour hearing. In 28 seconds, he would have gotten to, "Good morning, Your Honors." Right? There's no way that this judge actually did the review in this case. And because of that, I think we have to reverse on the constitutional grounds as well. I would encourage the court to go further and say that the court rule was unconstitutional as applied because it deprived due process. But I think at the very least, we have to reverse so that the court can have an actual substantive review of the facts.
I guess I've never, I don't know, I know you've practiced extensively in this area, if I'm not mistaken. I know I've had you on a number of these types of cases. Have you ever seen anything like this in any of your prior escapades, shall we say, regarding TPRs?
Certainly not this fast.
8-second review?
Not this fast. I had it show up one other time in an adoption case, but it was not this fast. It was more like it was right on the 7-day mark.
Okay.
Well, then how about a referee that addresses one of 4 grounds?
That's true, Your Honor. We could definitely fault the referee for not addressing the rest of the grounds that were raised. And as I said, brother counsel suggested an alternative ground, but even there, we can't transfer it. And even if we tried, it wouldn't line up.
Thank you.
I'll reserve the rest of the time for rebuttal, but since Your Honors are quiet on this one, I'll take that as a sign to shut up.
Good afternoon, Your Honors. May it please the court, Mikhail Patrick Salcina on behalf of the petitioner appellee of the Michigan Department of Health and Human Services, Newaygo County. I take that the judges here have thoroughly reviewed the briefs presented, and I guess I would ask if you have any questions based on the questions that and arguments of Ms. Schmidt.
No, I feel bad for you in this sense, counsel. I mean, you got stuck with a bad record that you had no control over whatsoever. This is actually court as opposed to lawyer error.
Well,
some of it, yeah, not all of it, but some of it.
So let me ask you this question. So where in here, other than on the first day of the termination trial, were the grounds for termination provided?
Your Honor, I don't know whether they were, I don't believe that they were explicitly provided in the termination petition, although I do know that it was noted in the termination that this was an aggravated circumstance and that the petition did specifically request a termination of parental rights via statute.
Okay. So you're saying that it wasn't ever in the record, but what was in the petition was sufficient to provide notice?
I believe so, Your Honor.
I don't have any additional questions, Judge.
And so you have no problem with the 28-second review? And no findings of fact?
That's
referee addressing one of 4 grounds?
I do find it troubling. I wish the court would have created a better record on the multiple grounds for termination of parental rights, certainly, because I do think there were grounds that the court could have found that would have created a better record based on the evidence presented at the court. Further, Your Honor, I was not aware that it was 28 seconds. I did realize that it occurred the same day. That, Your Honor, if it was truly 28 seconds, would be troublesome to me, Your Honor. Although I would know, as said in my brief, MCR 3.991A does specifically provide for a mechanism for review once an order is entered. Further, in this case, Your Honor, I'm not as concerned about concerns about due process with respect to this issue because Mr. Dornbos had an appeal to the Court of Appeals by right in this sort of case once the court had entered its order. Therefore, there was certainly an opportunity for review. Mr. Dornbos has availed himself of that process.
So can I ask this? You have a contract with DHHS to represent them?
I do, Your Honor.
Okay.
You might want to tell them that, this wasn't the easiest case to defend.
Without going into privileged conversations,
okay,
I will note that.
Please don't. But so one of counsel's points is, and what the referee in this case did, and obviously the underlying allegations involve sexual abuse, and these are young boys, and the referee, I think it is a logical inference for me that at some point there's going to have to be a conversation with these young boys about what happened with their half sister, and why dad's rights were terminated, and why dad is removed himself from the lives of these children by his actions, right?
Certainly, Your Honor.
I mean, it's just a hard situation where you can't talk to, you don't want to be having these conversations with children that of the age of these boys. But it's going to have to happen, especially when mother is now the safe person for this young child. And this is, I guess, directed toward both of you. I mean, nobody here is challenging the termination as to the adopted daughter.
That's my understanding, Your Honor.
And normally, if it's reversed, it's reversed. But here, I think since nobody's challenging it, I assume that we're leaving it intact since that challenge is not being made. Am I correct about that, or am I incorrect about that?
That's my presumption, Your Honor, but you'd have to ask sister counsel.
All right. Ms. Schmidt, I know that the challenge is solely to the termination of, the younger male children.
Yes, that is correct, Your Honor. I have a suspicion. Well, no, I'm going to say it this way. The record that is before the court right now is probably sufficient to uphold with regard to the daughter based on the therapist's testimony. So we are not challenging as to the daughter, only to the sons.
Okay. All right. We'll accept that. Does anyone else have any questions?
No, thank you for clarifying that.
I see no other questions. Okay. All right. Thank you both.
Again, thank you
for the
both. Excellent
briefing.
job.
Yep. And that matter is submitted, and we'll move on to our last case for this case call, which is item number 21, docket number 376-069 and 375-986 in Ray Gold Miners. And we have one person appearing by Zoom in 376-069. But first,
this is Gould, right?
We have, is it Mr. Swears?
Yes, sir.
Okay, I think you are up first.
No.
Oh, do I have that wrong?
Well, I think
are you the appellant?
So we
You're
are
the
the
You're the appellee.
appellee as it relates to as it relates to both. There's no preserved oral argument as it relates to Mr. Gould from the appellant. So it's just, I suppose, I only have brief comments to Mr. Gould, and I'm happy to take it after.
I'm
Mr.
sorry,
Deal.
yeah, because of the consultant.
So
Long day.
yeah, if it would
Sorry.
be easier for the court, I think personally, I think it would make more sense for Mr. Deal to address Ms. Fitch's argument than I can just speak as.
Is that how you'd like to
both
do it?
parents, that's fine.
However the court prefers.
That's fine. Yeah.
That okay?
That's fine.
Okay.
All right.
Thank you, sir.
All right, go ahead, Mr. Deal.
Good afternoon, Your Honors. May it please this honorable court, Ryan Deal on behalf of appellant Carrie Fitch. I come to this court today without a pin of any kind today. Apologies for that. Yeah, I have heard all of the oral arguments, and there's been this morning before the court, there's been a lot of really, really thoughtful arguments. I also want to thank the court for the opportunity to appear by Zoom from such a far-flung location as Oakland County.
Middle of nowhere.
Middle of nowhere. I just wanted to, if the court, I know the court's read the briefs and read all the arguments and reviewed the record. I'm only here to answer any questions that the panel may have, if any.
Appreciate your briefing here, counsel. I don't have any questions. PJ.
I have no questions, but I do want to say, we do appreciate you coming in these termination cases because a lot of times we are left sitting here with questions and nobody to have them, nobody to respond to and provide answers. So thank you for appearing.
My pleasure.
I see that we don't have any questions, so we will turn it over to Mr. Swears.
Good afternoon, may it please the court. Jordan Swears appearing on behalf of the Muskegon Department of Health and Human Services, and I will join brother counsel in noting for Judge Borrello that since joining the prosecuting attorney's office, I have never been given a pen of any sort.
That's just wrong.
Have self-supplied.
To the bad situation.
Although I will note I do have a very large fluffy cat, so I'm at least in line with the court as that.
Well, that was Miss Parker with the cats, right? Maybe you ought to get with Miss Parker and see if your cats could have a play date.
I think my concern is if I spoke with her, my wife might decide I need more like 7 rather than 1. Similar to brother counsel. Yes, I have always been a cat person. I've never had that many cats.
One time, right?
At one time. I think maybe in total over 40 years.
There you go.
Yeah.
Similar to brother counsel as it relates to Ms. Fitch, I have no argument to offer the court. I'm just happy to answer any questions.
I don't think we have any. The briefing was.
No, the briefing was really good, really good.
So thank you for that. And thank you both for being available for any questions that we had or anything.
Appreciate your time.
So thank you so much.
Thank you very much, Your
I do
Honors.
have one brief thing I would like to add as to Mr. Gould's arguments, the court would indulge me. And I am aware that I am batting cleanup today and moving into the lunch hour, but there's I was noting actually to Attorney Speaker earlier, I think the only time I've not been batting cleanup before this court, I was arguing against Attorney Schmidt and she had jury duty and we were allowed to argue first. Regrettably, she was not impaneled. The one thing I neglected to address in my brief is to Mr. Gould that I thought was worth at least noting for the record is as to the ineffective assistance of counsel claim. One of the points reiterated by sister counsel in briefing as I was reading it is that Mr. Gould appears to take issue with at several points in the record during review hearings. His first attorney, who was not counsel at the termination hearing, appeared to be essentially supporting the agency or the department's position to the detriment of Mr. Gould. There were comments where he was essentially apologizing or acknowledging his client's behavior, some fairly outrageous comments made about the court or about caseworkers throughout the case. And I did just want to note, to the extent this is relevant at all, the somewhat unique position of an attorney representing a parent in a child protective proceeding. These are obviously probate proceedings rather than a criminal proceeding, which it's one continuous and ongoing proceeding from the initial petition through either the return of the children and closing of the case or the termination. And it's frequently necessary for counsel not only to act as an advocate on the specific legal issues, but to act as a coach and mentor to a parent. Since our desires, we start with the presumption that you are no longer fit and proper as you sit and appear before the court at adjudication, and we wish to restore your ability to parent the children. And it's necessary for counsel in these proceedings frequently to, for lack of a better term, admonish their clients in front of the court to essentially try and mitigate or dull the sharp edges while they move towards restoring those parental rights. And when I read the record and some of the concerns regarding Mr. Flynn's performance at those hearings, I don't read them the same as they're presented to this court. I read it as an attorney who has practiced for many decades attempting to move his client from a position where he's not trying to score a minor legal victory. He's trying to get him to a point where he has addressed those barriers. And unfortunately for him, that was never going to happen. And I think what's most telling on that point is simply when successor counsel at the termination hearing placed Mr. Gould on the stand and asked a question they referenced in their, or we referenced in our brief. The first question out being, I'm going to start kind of out in left field. And so we keep hearing about you're going to picket, you're going to sue, you're going to sit outside the judge's house, are things you were going to do. I think most attorneys know what you're asking for is no, I was distraught, I was upset. And Mr. Gould's answer in court was, I'm going to do what it takes to get my boys back. Whatever Mr. Flynn did, whatever Ms. Goodwin did, I believe was done out of that understanding of the nature of a probate proceeding and their best attempt to represent Mr. Gould. But no matter what any counsel did, it was clear that Mr. Gould was never going to listen to the court, to his own counsel, or to the social workers. So I just wanted to readdress that briefly, simply because I understand that read in isolation, many of counsel's comments could be taken as essentially conceding a point that in a criminal context would be problematic, but in a probate and child protective context is really, I think, best viewed as not necessarily just an extension of the social work aspect, but certainly part of that attempt to restore parents' ability to be with their children.
I think it's actually more technically now the family. So
Yes.
it started with probate and now it's in family. But you have to connect the statutes to get there.
Yes, and we have a few where I've had to brief for the trial court that revised Judicature Act, but ultimately it's certainly not a criminal proceeding. Our goal is never to punish. Our goal is wherever possible to restore families.
Well, and I'm really grateful you brought that up because I think statistically, the security concerns for judges emanate more so out of the family matters that are heard as opposed to in the criminal context. And these were very frightening and inappropriate statements that had to be confronted. So thank you for acknowledging that.
Thank you, Your Honor. I think it was best put to me by a professor in law school, which despite my age was not as long ago. I'm a late convert to this field of practice, but that for many criminal defendants, the point of highest tension is that point of arrest. By the time you're at trial, they kind of understand what's happening. When we're dealing with family court, unfortunately, because these are repeat proceedings, we sometimes lose sight of how important this is. And that while we're unfortunately by the time of termination, frequently almost dealing with a fait accompli because we've had this record before the court for years, we're still talking about not just a fundamental liberty interest, but someone's children. And I think it warrants a degree of compassion, and that the parents who appear before us, even when we're terminating their rights, never started out wanting to be in this position. Almost no parent that we ever have before us would have sat down as a 16 or 18-year-old planning out their life and said, this is how I want to be, whether it's a substance abuse issue or a mental health issue. These are simply proceedings that unfortunately are necessary in our society, but have to be treated with that degree of compassion.
Thank you for that.
Appreciate it. All right, thank you both. And that
Thank you for the
concludes our
court for
this
indulging
call
me.
Thank
for
you,
today.
gentlemen.